For pronouncement of judgment from the supplementary cost list, item numbers 48 and 49.
Petition is dismissed. I'll sign the other pages later.
For judgment, item number 50.
Impin order is set aside, petition is allowed.
For judgment, item number 52.
Petition allowed.
For judgment, item number 53. 52.
This is the last. Petition is dismissed.
For judgment, item number 53.
Petition dismissed.
May I please, your Lordship?
Yes.
May I have your Lordship's indulgence to mention item 55 to 58. This part health matters, which has
Yes, we'll take
to
this up
maintain
first.
continuity.
Mhm.
May I pray that this matter may be upgraded before the regular admission matters, Lordship.
Yes, you call this out first, okay? Yes.
Like,
Yes, any other mention?
With this Lordship,
Mm.
my Lord, I beg to mention hearing item number 44.
Mm.
My Lord, I have a prayer that may this matter be listed after 3 weeks, my Lord.
Item 44. Donor Council for the petitioner has
So,
paid for, yes,
If date may be fixed, you know, 18th of August
okay. Learned
for the
Council,
petition.
okay, Learned Council for the, oh, you are for the respondent.
No, I am the petitioner.
Item 44, item 44.
For responding number 4, my Lord.
Council for the respondent number 4 has prayed for adjournment of the matter. Stop. The Learned Council for the petitioner has prayed for listing the matter on
18th of August.
18th of August.
If there's an interim.
Okay,
Then
stop.
can
Prayer is
continue.
allowed. List the matter on 18th August for hearing. The interim order passed earlier shall continue till the next date.
Pleasure.
My Lord.
May I please, your Lordship, may I be pleased to mention item 45 and 46.
Hmm.
Your Lordship, I've heard that like even the matter will be take the whole day. So if you can
Yeah,
speak
it-
on
Hmm.
Thursday, your Lordship, on a
Um,
consensus prayer.
Okay. On the prayer of the parties, list the matter on Thursday. Thursday will be, give the date, okay? Yes.
Much obligement.
With bless your ladyship.
Yes.
My Lord, I clerkly mentioned item 41.
Letter 41.
I'm representing the state here. I am in receipt of the instructions from the department, so I may be allowed the 3 weeks time to file the counter.
Learned, yes, learned senior government advocate, Mr. Mua Imchen has prayed for 3 weeks' time to file affidavit in opposition as he has received the instructions. Stop. Learned counsel for the petitioner has no objections, list the matter after 3 weeks.
May I please, my lord?
Yes.
Lordship, I beg to mention item 43.
Uh,
Lordship, I am for the state respondent 1 to 4.
hmm,
I am yet to receive instruction in this matter. If
Hmm.
3 weeks' time can kindly be granted, my lord.
Lordship,
Yes.
this is with regard to making advertisement. The respondent government has failed to make 3 consecutive years advertisement, though there are more than admittedly through RTI, more now 107 vacancy.
Hmm.
3 years, they have been advertising only backward quota only for 3 years without advertising general quota. So it needs emergency disposal, and this may be the last time. Lordship.
Lordship, in fact, after issuing the notice of motion, this is
Ah.
the second time the matter has come up. And
Yes.
moreover, Lordship, I
Ah.
think notice upon the respondent number 5
Hmm.
also has not been completed. I'm not representing respondent number 5, my lord.
Who is respondent number 5?
NSSB, who is
Oh,
supposed to conduct the examination, your lordship.
Of course, we
I'm not
have,
representing
we
that.
have,
Taken steps.
yes, taken steps.
Let's see whether notice is complete. Item 48, 43. No. Then a senior government advocate, Mr. N. Angami, has prayed for 3 weeks' time to file the affidavit in opposition. Stop. The service report is still awaited. Office note dated 18/7/2025 indicates that return service report in respect of respondent number 5 is still awaited. So accordingly, prayers allowed list the matter after 3 weeks to enable the learned senior government advocate to file the counter affidavit.
Obliged. I'm deeply obliged.
Learned counsel for the petitioner, Mrs. Zimomi, is present.
Obliged.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 15 to 37, Lordship.
Hmm.
Lordship, here the state respondent has already filed an affidavit, Lordship.
15 to
15 to 37, Lordship.
37, okay.
Lordship, I'm appearing on behalf of additional AG LT Santam, Lordship.
Lordship, it's 15 to 23.
23, 15 to 23.
23.
Upon-
Hmm.
Lordship, if this matter can come up after 2 weeks, Lordship. I've been instructed to listen.
Counter filed.
Lordship.
Readings are
status.
complete.
Okay, okay.
If
Yes.
this matter can also come up on the 18th, then my senior will be out of station for 2 weeks.
Learned government advocate, Ms. Zimomi has prayed for listing the matter after 2 weeks. As the learned additional AG, LT Sangtam, who's appearing in this matter, has some difficulties today. Stop. Learned counsel for the petitioner, Ms. Lucino, Lucino is present. And prays for listing the matter on 18th of August. Okay. 1, 2, and 3. Okay, before that, you say learned counsel, Mr. Sintianger appears for respondent number 1, 2, and 3. The pleadings are complete. Accordingly, list the matter on 18th of August as prayed for by the learned counsel for the petition. Yes.
Lordship, I have similar prayer for item 38, Lordship, on behalf of LT Santam. Lordship, here also the state respondent has already filed an affidavit in opposition.
Learned government advocate, Zimomi has prayed for how much time?
2 weeks' time.
2 weeks' time. As the learned additional AG, LT Sangtam has some difficulties today. This is the matter after 2 weeks. Learned counsel for petitioners. Item 38. You have obtained the consent petitioners,
No, Lordship, I have not taken the consent. No.
item 38
Three.
is, they are asking for 2 weeks' time.
Your lordship.
Yes, learned counsel for the petitioner, Mr. Joshua Sheki has no objections. Yes.
Your lordship, here the Union government is also supposed to bring some instruction, but with or without the instruction on the next day, the matter may be heard if it can be reflected because my
Union-
client has been
Okay,
terminated.
Union
from
Wells,
service.
Mr. Yangarwati.
This is a service that is after retirement from active service.
Mm,
So my lord, years are also limited. And this matter has been pending for quite some time now, since last year.
mm.
So on the next date, if it may be reflected in the order that it will be disposed.
No, they're saying pleadings are complete, isn't it?
Lordship, we have already filed our.
Yeah, pleadings are
Yes,
complete, but Mr. Sanctam has some
But the
difficulty.
union was also saying that he'd like to seek some instruction, but no instruction is coming at all.
Mm.
So if the matter may be heard in the next date.
So, and you add another line, none appears for the respondent number, such and such, the Union of India. Stop. Verbally, they were instructed or the order is there?
Your lordship, he was seeking time, the counsel for the Union of India.
Anyway, we'll see the next day,
Your lordship,
after 2 weeks, yes.
union is a respondent number 5. Bless your lordship.
Lordship, I beg to mention item number 38, 39.
39.
Actually, the matter was fixed today, Lordship,
Mm,
but because of the yesterday's part of matter, Lordship,
mm,
this might not reach properly. It's there's an urgency in the matter.
Mm.
It is to dissolution of the village council.
mm.
Also, and in fact,
Pass over,
chief
then?
on
Mm.
Tuesday,
Thursday,
Yes.
okay.
because there's an urgency. My tenure is getting over next year.
Acha, 39, Thursday, list on Thursday, the consent of the parties.
Oblige, your Lordship.
Yeah, please, Your Lordship.
Yes.
I'd like to mention item 37.
Hmm.
I pray for 3 weeks to file an affidavit tonight.
Learned-
no objections.
Okay, Learned Government Advocate, Mr. M. Longkama prays for 3 weeks' time to file the affidavit in opposition. Stop praise allowed. Learned Counsel for the petitioner has no objection. Cynthia Maha, Counsel, list after 3 weeks.
Much obliged. Lordship, I beg to mention item 40, I have taken the consent of the opposite party.
4-0.
Yes, 4-0.
Hmm.
I want to file a short affidavit in the IA. So I may be kindly granted 2 weeks.
Okay, here you are appearing for
The petitioner. And
petitioner.
in the IA, I am appearing for the opposite party.
Okay. Learned Counsel, Mr. Cynthia Nga, appearing for the opposite party in IA 73 of 2025, has prayed for 2 weeks.
Yes,
2
madam.
weeks' time to file file an affidavit in the IA. Stop. Prayer is allowed. Learned Counsel for the petitioner, serving such is present, list after 2 weeks.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next date.
Much obliged.
Please, Your
Yes.
Lordship, Your Lordship, I beg to mention item number 42.
42.
Yes,
Okay.
my Lord, Your Lordship, here I am on behalf of Aileen Mantushi
Hmm.
for respondent number 8.
Hmm.
Your Lordship, we will be filing Vakalat Nama within a week.
Hmm.
So kindly, it may be listed after 4 weeks.
Okay, Learned Counsel, MS such and such has submitted that Mr. Learned Counsel Lima Toshi will be entering appearance on behalf of respondent number 8,
Yes, ma'am.
and therefore prays for how much time? How much time? Three.
Within a week.
Prays for 1 week's time to file her Vakalat Nama. Learned Counsel for the petitioner, where's the petitioner? Petitioner is not present. Prayer is allowed, list after 1 week. Yes.
Lordship, kindly list the match after 4 weeks for filing affidavit in
4 weeks.
opposition. Yeah, for filing affidavit in opposition.
Okay, then list after 4 weeks in order to enable the respondent number 8 to file affidavit in opposition. Yes. Learned Government Advocate, such and such is present. Yes.
Yeah, please, Your Lordship. Lordship, I also beg to mention item 24 to 35 also.
Item
Item 24 to 35.
24 to 35.
Lordship, here the state respondent is yet to file affidavit in opposition. Lordship. So if Lordship may please to grant another 3 weeks time.
Lordship, in this case, I'm put a petition. From the month of May this year, you have taken the time.
Mm.
It was your submission that the affidavit is under preparation from the month of May.
Lordship.
Under preparation or not yet received?
Then you have
We have
received the
received the
instruction.
instruction.
That
Lordship.
was your submission before this.
Under
some-
preparation.
For the last 2 months, they are, affidavit is under preparation.
No, it
Lordship,
happens
well-
when you're in the government panel, it happens. To enable the government advocate to file the counter affidavit.
Lordship, the union is also a party.
Oh, okay. Yes, you'll also file.
Maybe some. Issue that who is supposed to.
Oh, it's on the way. Okay. Learned CGC, Mr. Gauhati has also prayed for 3 weeks' time to file his affidavit in opposition. Stop. Yes.
Also back to mention item 57.
57,
47.
47. Hmm.
I don't know whether you know. August.
Yes, you want another date?
Yes.
Item 47. On the prayer of the parties list the matter when?
Lordship, 18 of August, 18 of August.
On 18th. We're putting many matters on 18th August.
We are special lordship.
Okay, 18th August.
Yeah, please, Your Lordship, maybe please to mention admission item number 1. Your Lordship, here I received an instruction, Your Lordship. However, I need to have a further clarification because it's relating to a technical matter, fixation of pay. And there's some thing which I'm not being able to completely understand it. That's why, Your Lordship, I need further clarification on the instruction that I have received. So if this matter can come up after 2 weeks.
Regarding fixation of pay.
There was an error in the fixation pay of the petitioner. So accordingly, the government, they were taking steps in considering the case of the petitioner. And so today was the day we are supposed to close the case. But last night only when I received the instruction, I felt that there's still some incomplete instruction which I need to seek it in. There's some clarification I need to make. It's a technical matter.
Maybe it
so-
can be disposed of at the admission stage.
If that
okay?
submission, if that submission get recorded.
Yes,
Yes,
that
yes.
can be.
Learned government advocate Livika has prayed for 2 weeks' time to receive further instructions and has submitted that the matter can be disposed of on the next date at the admission stage. Stop. Accordingly, prayer is allowed. List the matter after 2 weeks. Stop. Learned counsel for the petitioner to Shri Longkomer is present and has no objections. Stop. Yes. After 2 weeks.
May I please, my lord?
Yes.
My lord, I have instructions to appear for respondent number 12 in item number 4. These are analogous matter from item number 2 to 14.
2 to 14.
2 to 14, yes. And in I have been implemented as respondent number 12 in item number 4, that is the Judicial. I have instructions to appear on behalf
So you will appear in item number 4.
my
Item number 4 only.
my lord,
For R12.
R12. So kindly grant 4 weeks time to file my Bakalana and my counter affidavit.
Lordship.
Oh, this is that case where
Yes,
notice was
exactly.
not completed. No, that means they have received the notice only now.
I've yet to receive the Bakalana.
Okay. Learned counsel,
I Jamil.
I Jamir, has prayed that he has submitted that he has received instructions to appear on behalf of respondent number 12 in WPC 188 of 2023 and accordingly prays for 3 weeks time to file 3 weeks or 4 weeks time. 4 weeks.
I'm preparing for the first time. my lord.
Yes. 4 weeks time to file his Vaklatnama and affidavit in opposition if so advised. Stop. Prayers allowed. List the matter after 4 weeks. It's okay. They are appearing for the first time.
Much obliged.
This is. These are all analogous matters. Yes.
Yeah, this lordship.
Yes.
My lord, I beg to mention item 36.
Mm.
My lord, if this may be passed over for the day.
36.
Yes, 36.
Okay, pass over for the day on prayer of the Learned Counsel for the petitioner, Mr. Takakichu. Learned Counsel for the government, government advocate has no objections. Pass over.
Like-
36.
From the supplementary cost list for motion, item number 54.
Who's appearing? Moy Jamil. Yes.
The lordship, this instant writ petition is pertaining to painting liabilities, painting bills amounting to 95,718 for the period of 2004 to 2017, your lordship. Your lordship, White Office Memorandum dated 28 May 2021, which is in Annexure 2, page number 21. Annexure 2, page number 21.
Page 20.
Annexure
Learned
2.
Counsel, there's no paging. There's no paging in your petition. Only the annexure number is given to see. What happened? Just see your annexures. It's not paginated.
So your lordship, this modification is issued by the Transport and Communication Department, where they have internal list of firms to undertake repairing, replacement, and also to supply motor parts. And also to
Where are
repair-
you? Serial number?
Serial number 37, your lordship. So my firm was also internal under Mon District to carry out such duties, your lordship. And thereafter.
This
your
is
lordship-
when? 2001.
2001, your lordship.
Then?
Since then, my firm has been doing all the duties as assigned, and in Annexure 3, page number 28. The department used to supply such kind of list that is required to be supplied by the petitioners. So this is of one such list that is produced by the Superintendent of Police, Mon Nagaland. And in Annexure 4, it is the bail memo that is required to be produced by the petitioner before the Superintendent of Police, Mon Nagaland, stating the description, rate, quality, and total rate of the payment. However, your lordship, even after doing all such things, the petitioner have not received his pending bills till date. And Annexure 7 is the pending liabilities. Annexure 7, page number 43. Which clearly states the amount amounting to 25,718. And
Vehicle parts.
yes,
These are all vehicle.
pending liabilities is Annexure 7, page number 43.
Yes.
These are the liabilities from 2004 to 2017.
Yes, who's appearing? Yeah.
Yes, madam.
If these are not disputed, then you should clear it, na?
Lordship,
Clear it up,
yes. But
why keep it pending?
Your lordship, there appears to be a letter. If my lord can kindly come to page 45. This is a letter written by the
Page 45.
45, my lord.
45.
Page
No,
40
page
45.
Page 45, these are all the list of materials which have been supplied by them.
Lordship, there are in fact two writ petitions filed by them. I know which they are referring to.
Your lordship, only one writ petition is
No,
today.
only one writ petition. WPC 125.
That is about 95 lakhs 25,780.
So this is regarding pending bills.
Yes, yes,
Uh,
Lordship.
amounting to 95 lakhs, 25,718.
In fact, they have served two different writ petition. One is amounting to 22 lakhs 55,000 and 200, and I think that is not listed today.
Yes, Your Lordship.
Lordship,
One was listed today.
Yes.
The one before me is 95 lakhs.
Yes,
95 lakhs.
Lordship, notice may be issued in.
Yeah, you get some instruction.
Yes,
then-
if notice may be kindly be issued, Your Lordship, so that
Third learned counsel for the petitioner, Miss.
Saifani.
Stop. This is a petition. Under Article 226 of the Constitution of India, praying for release of the pending bills of the petitioner amounting to rupees 95 lakhs 25,718 for repair/replacement of government vehicles and supply of spare parts to the office of the Superintendent of Police, Mon, Nagaland. Stop. Learned Senior Government Advocate, Mr. N. Nangami, has accepted notice on behalf of
all the respondents.
all the respondents, hence no formal notice is called for. Stop. Notice. Notice is issued, returnable within 1 month or 4 weeks, within 4 weeks. Stop. The petitioner shall supply extra copies of the petition to the learned government advocate during the course of the day. Stop. The learned government advocate will receive instructions as to whether these pending bills are undisputed, and an effort will be made to dispose of the petition on the next returnable date. Stop. Yes.
Obliged, Your Lordship.
Just after 4 weeks.
For admission, item numbers 55 to 58.
Your Lordship, before that, Your Lordship, petitioner just came and say that maybe the matter might not be over. So item 59 also, Your Lordship. If you can come up on tomorrow.
Item 59. Okay, pass over for the day on the prayer of the parties.
Much obliged. With this, my lady.
Yes.
Yesterday I could not place one judgment, so they placing 2006, then SCC 337.
1 minute.
2006,
2006.
then SCC
Then SCC
337.
337.
Ekta Shakti Foundation versus Government of NCT of Delhi. Excuse me.
You have the copy.
2006, then SCC. Page 341. Page 341, para 11. Para 11.
Yes, bottom at the bottom.
Yes, para 11. While exercising the power of judicial review of administrative action, the court is not the appellate authority, and the Constitution does not permit the court to direct or advise the executive in the matter of policy or to sermonize qua any matter, which under the Constitution lies within the sphere of the legislature or the executive, provided these authorities do not transgress their constitutional limits or statutory powers. Asif Hamid versus State of J&K, Sri Sitaram Sugar Co. Limited First Union of India. The scope of judicial inquiry is confined to the question whether the decision taken by the government is against any statutory provision or is violative of the fundamental rights of the citizen or is opposed to the provision of the Constitution. Thus, the position is that even if the decision taken by the government does not appear to be agreeable to the court, it cannot interfere. The correctness of the reasons which prompted the government in decision-making taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. The policy decision must be left to the government as it alone can adopt which policy should be adopted after considering all the points from different angles. In the matter of policy decision or exercise of discretion by the government, so long as the infringement of fundamental rights is not shown, the courts will have no occasion to interfere, and the court will not and should not substitute its own judgment for the judgment of the executive in such matters. In assessing the propriety of a decision of the government, the court cannot interfere even if a second view is possible from that of the government. The court should constantly remind itself of what the Supreme Court of the United States said in Metropolis Theater Pro versus State of Chicago. The problems of government are practical ones and may justify if they do not require. Rough accommodation, illogical it may be, and unscientific. But even such criticism should not be hastily expressed. What is best is not always discernible. The wisdom of any choice may not be disputed or condemned. Mere errors of government are not subject to our judicial review. Worship, that's all. Much obliged.
You're for respondents number, Mr. C.
Respondent number 4 to 12. 9 respondents. We had doctors appointed on contract in 2012-13 and continuing in the service. And in the list which my learned friends have referred yesterday, the names are also included in the list. Yesterday, Lordship has heard the matter at length and elaborate submissions have been made by all the councils. So Lordship is fully conversant with the facts and most of the relevant documents have been referred to. So I will not refer to all those documents, but except some relevant portions. And so far as facts are concerned, my learned friend Kamasa as well as
Yes,
my
on
learned friend
fact,
Lima
yes, on facts, we need not. Yes.
refer to all the documents. Lordship is well aware the filing of the writ petition is basically based on the service rule. And taken a plea that look, the two cabinet decisions are contrary to the provisions of the service rule. So the entire argument was based on the violation of the service rules. The recruitment rules have been violated, and the cabinet decision is not proper and not in accordance with law. And if it all you want to do it, then first you should have amended the rules. Thereafter, you could have done it. That was the main thrust of the submission of my learned friend. And in fact, ordinarily, under normal circumstances, I would also agree with him on that argument. But as Lordship has seen yesterday, the present issue relates to a situation, extraordinary situation, which has occurred in a peculiar situation, which was not anticipated by human beings. So it is an extraordinary situation and circumstances in the human history. My learned friend has referred to so many judgments, but these are relevant under normal circumstances, but not in a situation like this. And I was expecting that my learned friend would argue and make submission under genuineness and authenticity and validness of the two cabinet decisions, because these two cabinet decisions categorically states that it is a one-time special measure which cannot be taken as a precedent in the future. That means this is an extraordinary decision which was decided during COVID-19 pandemic. We can remember also, our memory is fresh. What was the situation during the COVID? Persons who were working, the medical professionals, many have resigned. They have quit their job for fear of life. But the respondents are the persons, are the ones who has risked their lives, who has sacrificed their life and work during the COVID-19 pandemic. Therefore, the decision of the cabinet was taken during an extraordinary time, extraordinary situation. And in order to tackle extraordinary situation, extraordinary decisions are required to be taken. That is very important. In a peculiar situation, peculiar decision is required to be taken. And that is what the government has taken. Now, it was a warlike situation. Even we were so scared and afraid to talk each other. Among the family members also. Situation was totally different. It was like a warlike situation. And nobody was moving on the street. Now we have forgotten. Everybody is moving freely. No restriction. But that was a time. There was a time when even we were afraid to go out, to venture out. And these two decisions have been taken during this time. So I was expecting that my learned friend will satisfy the Honorable Court and make submission on the point that the one-time special measure which was adopted by the cabinet during the COVID pandemic is unreasonable, and they should not have taken this decision because of this and that reason. In order to defeat the decisions, that should have been the relevant argument, because it was an extraordinary situation. While submitting their representation, they have referred to the one of the biblical passage, that is Colossians chapter 3, verse 23. In the representation, it is quoted. Now, considering this, I also feel it appropriate to refer and reply with a biblical chapter, which is appropriate with the present situation.
They're also very familiar with the Bible.
I try to be familiar.
Yes.
Proverbs 30, verse 18 to 20. There it says, there are three things which are too wonderful to me. Yes, four, which I do not understand. The ways of an eagle in the air, the ways of a serpent over a rock, the ways of a ship in the midst of the sea, and the ways of a virgin with a man. She eats and whips her mouth and says, I have done no wickedness. Whatever has happened, we don't see now. If a bird flies in a particular direction, now it will be very difficult to identify the areas where the bird has flown. That too in eagle. Eagle flies very high. It goes up to the sky. So we don't see now where it was flown. So also the ways of a ship. Once it is crossed, it is very difficult to show what was the boundary where the ship has crossed. So also the ways of a serpent, ways of a snake over a rock, which was the other end, which is the other. We don't see clean. Like that, we are feeling that COVID was dying when everybody was so scared and afraid and insecure. Now, everything is gone. We don't remember actually what was the situation. So the present 2 cabinet decisions have been taken in such a time when the situation was extraordinary in the human history. Therefore, extraordinary situations was required to be taken. And that is what it was taken. Now, my submission is this Honorable Court, while hearing this writ petition, should be mindful and should keep in mind that what was the situation during that time and why the decision was taken at that particular point of time. Not in the present context and not like any other ordinary writ petition that is filed under normal circumstances, talking about service role and all that. Yes, I agree. State cannot act contrary to the provisions of the service role. But there are certain situations where some alteration, deviation is required to be made by the state, so as to tackle with the situation, so as to handle the situation. And the 2 cabinet decisions which yesterday my learned friends have referred to are the decisions which were taken during that particular peculiar time. And it is a special measure, special recruitment drive. And we have to be mindful about the word special. What is special? That means it is not common. It is not similar. It is little peculiar and different from others. That is why it has to be done in this manner. Otherwise, suppose if it is made open, commando all, what is the purpose of formulating the scheme? Everybody will come and participate. That is open. So the meaning of special recruitment drive will lose its meaning. The very word special drive will lose its meaning. Therefore, a special and peculiar decision was taken. So far as submissions are concerned, I adopt the submissions made by my learned friend Mr. Takamasa, including the rulings which he has cited, including the refutal to the submission of my learned friend Mr. The counsel for the petitioner. I adopt his submission and support him, except one situation on one point. I have little deviation, that is, during the course of submission, he has made a submission that the policy is made as if it is only for the COVID appointees, because the very word starts with that COVID appointees, COVID appointees. It has become an accepted phrase, that COVID appointees. But it is not only COVID appointees, but the persons who have served during COVID pandemic. So appointed and served. So we have served. Who fulfills 100 days of COVID duty, who obtains certificate. So on that point, I would differ with the submission of my learned friend. It is meant for those persons who have sacrificed their lives during the COVID pandemic. In that regard, I would support the submission of the learned Additional Advocate General, Ms. Chokri, that when Lordship has met the appointed query on the referring to the documents of 280 posts, whether the contract appointees, that is respondent 4 to 18, I think, altogether, but I'm representing only 4 to 12. Yes, those contract appointees are also included. So I need not.
One slight difference is that as far as the other respondents, COVID appointees are concerned, they had to face an interview. They faced an interview. Whereas in your case, no.
We were contract appointees.
Yes, that's right.
Initial recruitment, yes.
Initially, you were appointed.
Yes.
Yeah.
But who has served COVID duty? That is the only criteria. And we were included in the list of 280. We were already in the list, which my learned friend has referred to. That is why I'm not referring. But my deviation is on that point only. And another deviation will come later on. That is with regard to the my learned friend has referred to the dental surgeons and all that. So, and filing up the writ petition and all that, that I will come in the later part of my submission. So that is the only difference I deviate from him, with him.
You were appointed between 2016 to?
No, 2012 to 2013. Most of us were appointed during 2012. And we are working more than 10 years now. Even under normal circumstances, in terms of the latest OM, we are eligible to be considered for regularization also. My next leg of submission would be with regard to the maintainability of the writ petition. My learned friend, Mr. Takabasa, as well as the learned Additional Advocate General, has also made submission on the issue of maintainability. And I am also making submission on the ground of maintainability, because considering the prayers sought in the writ petition, whether the writ petition is maintainable or not, whether the petitioners have the locus standi to question this, whether there is arbitrariness or discrimination or violation of the provisions of the service rules or not. So to question that, first thing first, who are the petitioners? Who are they? Yesterday, they have shown that serial number, petitioner number 1, petitioner number 11
and 55.
Petitioner number 55. 3 of them were qualified at the time when advertisement was issued during COVID time, and invited obligations that, look, we have this much of posts. Whoever wants to compete, they can come and compete. It was open, not secret. Open, they have refused to come. They were afraid. They were hiding in the holes during the wartime. And now the war is over. They are coming and then claiming that this entire area is my land. Something like that. They were no here. Rather, they ran away when applications were invited. So that is with respect to 3. Who are the remaining petitioners? They were just students. And they are questioning now, no, it has to be done, recruitment has to be done as per the rule. But what they are questioning about the decision of the cabinet which was taken during the COVID-19 pandemic. So, what locus standi they have to question this? So, first thing first, they should show that they have a grievance. They are aggrieved by the decision of the cabinet. Their rights, legal rights have been taken away by the decision of the cabinet. That is why we are coming. They should come in that way. But they are nobody. It's like, I would like to cite one example. It is like the son questioning to his father, before my birth, why you have done this? You should have waited for my birth to take this decision. It's as good as that. They were nobody. They were students. Therefore, no legal right of the petitioners have been violated in taking the decision because they are not the aggrieved party, because no rights of the petitioners have been taken away by the decision. They are strangers. It is just like a stray bullet they are trying to shoot. If it hits the target, then well, fine. Something like that. Now, coming to the issue of discrimination and arbitrariness. Discrimination can be among the similarly situated person, that Mr. A has been favored, but Mr. P has been left out, although they belong to the same group, same class, same category, but they were met two different groups. That is a situation where the issue of discrimination will come. In the present case, where is the discrimination? Let them show. Where is the discrimination? First thing first, they should show that we are equal. We were similar, but they were treated differently and we were treated differently. So it is discrimination. So this another court should interfere. They have not made out that case. Number one. Number two, they are talking about violation of Article 14. In order to apply Article 14, Lordship is well aware, they should be equal. Law should be equal to equally situated circumstance person. They are not equal. They belong to a different class. And what right do they have to question about the COVID time when they were in the college? And three persons who were eligible, when they were invited, they ran away. So, will it be appropriate to call them now and then, oh, during that time you ran away, now I want to reward you, come, please participate. Will it be reasonable? I don't think so. Therefore, no arbitrariness has been made out. No discrimination has been made out by the petitioners.
Yes.
The main thrust of the petitioner is under service role. So in what manner, under what situation and circumstances, the service role was amended or violated, how this was compelled, kindly come to my affidavit in opposition of respondent number 4 to 12. Page 18, Annexure C. Has the Lordship got it?
Yes, it is Government of India letter.
Yes, this is a letter by the Government of India, Ministry of Health and Family Welfare. And this was issued on 3rd May 2021, addressed to all the chief secretaries, principal secretaries, health, medical education, all states and union territories. So this is the guidelines issued by the Government of India. And for our purpose, I will take your Lordship's attention to paragraph 17 in the next page, that is page 19. In the bottom of the page, Lordship will find serial number 17. Paragraph 17. Has the Lordship got it?
Yes.
May I read? The central government recommends to state union territories governments to consider giving preferences in regular government appointments of health professionals through the respective public service commission, other recruitment bodies for those health professionals under this special scheme who complete a minimum of 100 days of COVID-related duty. So this was the circular issued by the ministry during that COVID pandemic time, when the situation was very, very hot. And the persons who have sacrificed their lives, so a special scheme has been framed, directed to be framed by the respective states, by the Union of India, who has to give special preferences, who has performed minimum of 100 COVID days of COVID-related duty. The respondents are the persons who have fulfilled this criteria. And in view of these directives, the cabinet has taken a decision. Lordship may kindly come to page 10, Annexure P. This is a cabinet memorandum. This memorandum has been prepared in view of the Government of India letter, which I have referred to your Lordship just now. And in terms of this cabinet memo, the cabinet has taken the decisions. Kindly come to paragraph 4. This has already been referred to. So I will refer to just relevant portions since Lordship is already conversant with this document. Paragraph 4. In consultation with PNR department, it has now been decided to relax the recruitment rules. This is a decision to relax the recruitment rule proposal as a one-time measure for the special NPSC recruitment track for medical officers and so on and so on. So it is a special recruitment track through NPSC and then relaxation of rules in the next page. Lordship will find Roman 1. Rule 15, sub rule 1 to sub rule 7. And as a special track, the weightage of marks have been given. This is only the marks that weightage should be given. Not that there is a direct conflict with the service rule says that you do this. No, don't do this, we will do by reverse. Not like that. But it is just like a supplementation because the government is very conscious about the directives and instructions of the Government of India and the provisions of the service code. And Lordship may kindly see clause 3. Contractual employees engaged by the government, including the NHM, NSEC, NHK, etc., who had resigned, this is very important, who had resigned during the course of COVID-19 pandemic or refused to accept the contractual engagement shall not be eligible for any weightage for rendering COVID-19 services. Look, persons who refuse, resign, shall not be eligible. Why? I cannot play pass and loss. In time of trouble, I will run away. When the situation is normal, I will just come and take advantage of the situation. No, that should not be allowed. Therefore, a special track, if it is made to all persons who has resigned and left the service will be eligible, that will make the special dispensation meaningless. That is very important. If it is left open to all, making everybody eligible, then what is the meaning of making a special dispensation? The policy itself will become meaningless. And then Roman 5, Lordship will find in the middle of the sentence, a paragraph in line 3, to those working on contract. So people who are working on contract are also included. And then page 14 will also be relevant. Page 14, capital P, COVID-19 duties. I will refer only just one paragraph. That is 1. The candidates concerned should have served in the government or private company. So serve. I just wanted to highlight the serve. Because submission was made that COVID appointees and the cabinet memo, some decisions are COVID appointees are mentioned. But persons who have served, they are also included. Contract appointees also. That is how out of 280 posts, the contract appointees are also included. Lordship has made a appointed query yesterday, and then the learned additional AG has responded to that. That is, it inclusive of all, and then these names are also shown.
Because by the cabinet, only certain posts were created.
Yes.
So that's why we wanted to know.
And lastly, I would like to refer to page 142 of the writ petition. This document has already been referred to by my learned friends yesterday. Only the relevant portions. In the bottom of the page, Lordship will find Roman 3 under paragraph 4. Roman 2, small Roman 2. 280 posts includes regular vacancies and also performed duty during the pandemic. So persons who have performed duty, these are included. And then can they come to paragraph 5, next page, 143. Approvals are sought from the cabinet for the above proposals as one-time measure to regularize the services of the health workers who had risked their lives. So it is a one-time measure, and we have risked our lives. So in view of all this, we were included in the list for the SRT. Now again, when Lordship is with the writ petition, I will come to the submission of my learned friend for the petitioner, counsel for the petitioner. In the beginning of his argument, he has referred to one document, that is page 108, the cabinet memorandum, the minutes of the cabinet meeting held on 11 June 2020. He has taken your Lordship to paragraph 1 and said that we are concerned with paragraph 1, but we are equally concerned with paragraph 7, 8, and 10 also. So can we come to the next page?
Page 109.
Yes, 109, paragraph 7, 8, 10. I will write Lordship. Regularization of 19 serving contract medical officers under the Health and Family Welfare Department. And then 8, regularization of 27 existing medical officers who were engaged by the department for a period of 1 year. And then 10 is there. The last paragraph, under paragraph 10. The cabinet further directed that this approval is in one-time relaxation of laid-down rules and procedures for recruitment, regularization, and continuation of age. Further, this one-time measure in view of prevailing situation in the backdrop of COVID-19 pandemic shall not be treated as a precedent. So as I was mentioning, Lordship, no submission was made. Why? One-time special measure is arbitrary, illegal, because this is the decision of the cabinet. So he should be able to satisfy this honorable court by making submissions that, look, they should not have taken this decision, although there is COVID-19 pandemic. But no such argument has been advanced under line, Lordship. And cabinet was very conscious that, yes, it cannot be treated as a precedent one time and cannot be treated as a precedent because they are very, very conscious about the provisions of the service code and about the overall situation. And the second point of submission was, of course, many submissions were made, but in important points which it concerns me, that the cabinet decision of 25th May 2022 has become redundant in view of refusal by the NPSC. All the documents have been referred to your Lordship, so I will not refer to all those documents. So in that regard, my learned friend Mr. Dakamasa has refuted and then made his submission, including which document was supposed to be challenged, was not challenged, in absence of challenge, the basic order, whether an order writ can be issued, or all these things, arguments have been advanced. I adopt his submission on that point. To save time, I'm not making any submission on that. So I am adopting his submission on this point, Lordship, that
basic
it
order
is a
not
part of
challenged.
a decision starting from 2020. It is a continuous process. Lordship is well aware how government functions. A thing which started in 2020 is culminating only in 2024. And there is no deliberate, inordinate inaction on the part of the state, but it was a continuous process and it was going on. So it has not become redundant. Now, page 147 of the petition. This is just to show the petition, respondent number 4 to 12. Serial number 1 to 11 are the respondent number 4 to 12. And they were saying that we were not COVID appointees. Cabinet decision, all these orders are saying COVID appointees and all that. But our names are included in the list also. And if we are not included in the SRT, then there was no need for the petitioner to implement us as party respondent. We have not filed any application for implement. It is the who has implemented us as respondent number 4 to 12. This very fact shows that some order is to be passed against us, and there is relevancy with the SRT. So what he is submitting and what we have done do not tally. But the fact remains that out of the 280 posts, the respondent number 4 to 8 are also included. Now, my learned friend has referred to page 154 of the writ petition. That is to show that earlier we have filed a writ petition, and then writ petition has been dismissed, and thereafter review was filed, and the review was also dismissed. Now, this judgment is ordered dated 13/2/2024.
Yes, 13 to 20.
And this has been reviewed by another order. In our affidavit in opposition. Affidavit in opposition of respondent number 4 to 12. For easy reference, let me refer to my affidavit, page
44.
27, no, page 27 of my affidavit. That is WPC 70 of 2023, which my learned friend has referred to. Here, a very important development has taken place. This writ petition was heard on 6/2/2024. Lordship will find in page 29 when it was heard. Date of hearing 6/2/2024. As your Lordship correct, page 29. It was heard on 6/9/2024.
6/2.
Yes, 6/2/2024. What happened, Lordship? After 2 days of hearing this petition, incidentally, the cabinet has taken a policy decision to regularize all those persons who has completed 10 years of continuous service, who were appointed against sanctioned posts and fulfill all the eligibility criteria. Then they should be regularized as a one-time special mission. That decision was taken after conclusion of the hearing. Hearing was done on 6/2/2024. Cabinet memorandum for regularization of the contract employees came out after 2 days, that is 8/2/2024. On the day of hearing, I did not have the magical power to visualize that after 2 days, cabinet will take a decision to regularize service. And interestingly, after that, the judgment was passed on 13/2/2024. In other words, between the date of hearing, conclusion of hearing, which was keep CAB, and the date of pronouncement of judgment, in between, there was an important development. That is the office memorandum of 8/2/2024, by which the state government has taken a decision, policy decision, to regularize all the contract appointees, as I have mentioned, who the categories, who has completed 10 years and above, who are appointed against sanctioned posts and possessing eligibility, requisite qualifications for the post. So, I was in a very critical situation. How to confront my clients? How to accept the judgment? Because the writ petition was dismissed on 13/2/2024. But in between, since there was already an OM, I filed a review application, which Lordship will find the judgment at page 44. So in the review petition, I made a prayer that, look, this development has taken place. We were not aware about this because it happened during the time when the judgment was, hearing was concluded. And before pronouncement of the judgment, this policy has brought in. So will be prejudiced, so kindly review this judgment. But then this honorable court arrived to a finding that if the review petitioners falls in that category, that means if we fulfill
10 years.
10 years, it is entirely up to the respondent authorities concerned to grant them such relief. So it is not that review has been dismissed, but then with that observation, the review was disposed of. So our option still remains and open. Even without this SRT also, it is open to the state government to consider our case for regularization, even under normal circumstances.
Where is that? Where is it?
Cabinet decision, Lordship will find it page.
No, where the court said that it's up to the respondents to
Yes.
grant them the relief.
Page 47. Last paragraph, and then just above that, 3 lines. If the review petitioners
Okay.
from the
Falls
middle
in
of the
that-
page,
Yes. It is
falls in that
entirely-
category, it is entirely up to the respondent
To- to
authorities
concerned to
concerned
grant
to grant them such relief. And I have also enclosed the policy of the government, which was taken in page 23. Relevant portion will be at page 24. Page 24, last part, agenda number 6. That's your Lordship got it. Policy for regularization of services of contract employees.
So one
The
point-
cabinet discussed and approved the policy for regularization of services of contract employees as one-time dispensation for all the categories of employees appointed prior to 6 June 2016. We fall under this category. Against sanctioned posts and who have completed 10 years and above.
So what happened to this? Because in other departments, I remember, in pursuance to this, names were collected and we had, even law department, we had sent to the government. So were your names sent? In
Yes,
view of
it
this?
it is also in the pipeline. So it is a 2-barrel gun. And the outcome of this case will have no implication with that. But then they have brought in. That is why I'm just apprising this honorable court the implications. What are the developments that took place?
No,
It
because
was
you have
heard-
been called for the screening also, isn't it? For the screening in view of the
Yes.
special recruitment drive.
Implication would be if the petition is allowed, then everything goes. SRT will go. Then it will be open and there can be no hurdle for the state to consider our case independently. One, if this petition is dismissed, the present petition is dismissed, then we will be subjected to set for the SRTs.
For the screening test.
We may or may not qualify. So the risk involved for us is much higher in this. Provided that the other
Because
policy
if we
is not
go
kept.
by this policy, automatically your case will be considered. Since you have completed 10 years,
Yes.
isn't it?
Yes,
But if you sit for the screening test, you may qualify, you may not qualify.
yes. But since we are implemented as respondent here, then we are clarifying on this. And the development is that the hearing was done on 6/2/2024. Cabinet memo came on 8/2/2024. And the judgment was passed on 13/2/2024. So between the conclusion of the hearing and the pronouncement of judgment, there was a very important development. That is how I'm trying to clarify all this. And then my learned friend has submitted that the review was also dismissed, but then it was disposed of with some directions, with some observations that if we come within that category, then it is open to the state to consider our
consider.
case. So, and then lastly, Lordship, my learned friend has referred to the Kohima case. That is a general principle, but I would like to make one relevant submission here. Kohima TV was decided on 10th of April 2006 by the Supreme Court. While passing this judgment, nobody could visualize that in 2019, COVID pandemic will hit the entire world. I believe among the judges also, none of them were having that magical power to know that after a few years, the world will be hit. Therefore, OMRDP was decided taking into consideration of the regularization of ad hoc contract appointees and then some principles have been laid down during that time. After the Omar Divi's case, Lordship is really aware. In deriving from paragraph 53 of Omar Divi's judgment, where the distinction has been made by the Honorable Supreme Court between the illegal appointments and irregular appointments. Many judgments have been passed, giving discretion, granting discretion to the state to take extraordinary decisions in the extraordinary times. Now, one of the decisions, if I remember correctly, that the Bar Association of Pandibara versus State of Jammu and Kashmir, which was decided in 2017 also, by deriving the ratio from paragraph 53 of Omar Divi's case, discretion has been given to the states for regularization of contract ad hoc employees. But my submission is the ratio laid down in Omar Divi's case is not strictly applicable to the present case, because the present case is dealing with the extraordinary situation where the extraordinary decision was required to be taken. And that too, state cabinet was very, very conscious about the provisions of the service rule. They have referred to, it's not that they were ignorant, they were very, very aware of all these provisions. But some decision has to be taken in order to combat with the pandemic. So decision was taken. And many have run away, many have resigned, we have volunteered. So consideration has to be given, a special consideration has to be given, and that was given, of course. Now, with regard to the citations, which my learned friend Kamasa and the learned additional advocate general has placed. Of course, one or two judgments which my learned friend has referred to my mind, these are not relevant taking into consideration of our case, because these are general principles. But then this is a peculiar situation, and all the citations has nothing to do with the COVID pandemic policy. That is why. And with regard to the low-cost standi, my learned friend has referred to 2013 4 ECC. I also have the similar citations. 2022 5 ECC 314, and then 2010 1 ECC 417 paragraph 28. These are all referred to by my learned friend. I have two rulings from my side besides those judgments.
Regarding maintainability?
No. Court is bound to take all the relevant facts and circumstances into consideration and decide the limited scope of judicial review. First, let me refer to 2009. That is just one paragraph. Paragraph 29. Paragraph 29, near it. In our opinion, the High Court, while exercising its extraordinary jurisdiction under Article 226 of the Constitution, is duty bound to take all the relevant facts and circumstances into consideration and decide for itself, even in the absence of proper affidavits from the state and its instrumentalities, as to whether any case at all is made out requiring its interference on the basis of the materials made available on record. There is nothing like issuing an ex parte writ of mandamus, order or direction in a public law remedy. Further, while considering the validity of impugned action or inaction, the court will not consider itself restricted to the pleadings of the state, but would be free to satisfy itself whether any case as such is made out by a person invoking its extraordinary jurisdiction under Article 226 of the Constitution. I have already submitted about the background and all this, so I'm not elaborating on that point. Next citation is limited, this is also on the limited powers of judicial review on policy matters. 2016 6 SCC 408, paragraph 21, 22, and 27. Let me first refer to paragraph 21. Let me not read out paragraph 21 and 22. Just let me read out paragraph 27.
27.
Yes. But both 21 and 22 are very important, but to save time, I'm not reading of this. The reason theory of discretionary power is that it promotes the decision maker to respond appropriately to the demands of a particular situation. This is very appropriate in our case also. When the decision making is policy based, judicial approach to interference with such a decision making becomes narrower. In such cases, in the first instance, it is to be examined as to whether the policy in question is contrary to any statutory provision or is discriminatory, arbitrary, or based on irrelevant considerations. If the particular policy satisfies these parameters and is held to be valid, then the only question to be examined is as to whether the decision in question is in conformity with the said policy. So, Lordship, I have submitted on all the backgrounds, under what circumstances the decision was taken, and in the rolling, the paragraph 21 and 22 are very important, but then to save time, I'm not reading. These are equally important. The whatever decision has been taken by the state government, all these decisions were under an extraordinary situation. And during the extraordinary situation, extraordinary decisions are required to be taken. So, Lordship, taking into account of all these factors, the petitioner has failed to make out the case. So, petition is liable to be dismissed. I conclude with that. What?
Yes.
I'm representing respondent numbers 13 to 18.
In 187, na?
Yes. In 239.
Oh, in 239.
239.
Wait. Respondent
13 to 18.
13 to 18. Okay. 5 minutes again.
Our appointments were also made in the year 2014 to 16.
Yes, 1 minute. Yes. 2014 to 16.
14 to 16. We're visiting 6 respondents, 15 to 18. So their nature of appointment is also similar with the other respondents, 4 to 12. They have also served during the COVID. They have imperiled their lives, knowing about the consequences. Now, since the legislative council representing 4 to 12.
I think your submissions would be
Yes,
similar.
I adopt the submissions made by the legislative council.
Yes, yes.
I forgot to mention a very important fact statement the other day. So, Lordship, COVID period, the COVID-19 was one of the rarest of the rare occasion when the Disaster Management Act of 2005, as well as the Epidemic Disease Act of 1897 were invoked together.
Yes.
Now, this becomes very important because in view of the invocation of these two provisions, besides the essential services, all other normal functionings of the government was suspended. Only essential services. And the cabinet took the absolute authority to make policy decision. For example, Lordship, for procurement of medicine and other COVID-related materials, the tendering process in NIT was done away with. There was no NIT, there was no tendering process. It was all from the open market through window shopping.
Directly, yes.
Because normal process, the NIT has to be issued tendering process for any contract supply work. So it was also suspended under that circumstances. This decision, that ordinary decision for recruitment was done. So, also we can take note of the fact that the decision of the cabinet was under when the Disaster Management Act 2005 and the Epidemic Disease Act 1897 was invoked. the rarest of the rare occasion when both were invoked in the history of India, of the country. In fact, Lordship, in view of this situations, in other parts of the country, COVID appointees were regularly appointed from day one. For example, in Kerala, the Public Service Act, the service rule was suspended, and 450 doctors who were directly appointed, like the present case, on regular basis. Unfortunately, unlike in other parts of the country where COVID appointees were appointed regularly from the day one, who were appointed on contract. Thereafter, this decision was taken. Much.
Yes,
Lordship, maybe allowed to make a short submission.
okay.
See, yesterday, Lordship, the council for the private respondent number 19 to 101. See, my learned senior counsel, he was referring to a judgment passed by his honorable and WPC number 36 of 2023. So as to issue that his honorable concurrent coordinate bench of this honorable as permitted to go for the special recruitment type. That was your concern.
Yes.
So should mechanically come the judgment passed in the WPC petition 36 of 2023. Should be the record. Since my senior counsel here
It is the compilation. I think that was read appeal 15.
Lordship, since the writ appeal is a continuation of the writ petition, Lordship, I want to refer to the order passing the writ petition.
WPC 36.
WPC 36. Lordship, my first condition is this WPC 36 of 2023. This was not disposed of on merit. Lordship, become the para 4. The order passing the writ. To be in the course of the, should call it para 4.
Yes.
In the course of hearing of the case, Mr. So-and-so, Lordship, our very also present here. For the respondent number so-and-so, on instruction, submits that the department will be making necessary correction. What was his in the impugn notification which is under challenge? He made the submission that necessary correction would be made. In the impugn notification which is under challenge. In the impugn notification, insofar as serial number 4 relating to the 5 posts of junior legal surgeon is concerned, by notifying the only 3 posts which was created by the cabinet in its meeting held to so shall be notified for recruitment through APC by the special recruitment tribe, in the remaining 2 posts of the junior legal surgeon shall be recruited strictly in terms of Nagaland Health Services Rule 106. Mr. So-and-so, learned counsel for the petitioner is not averse to the submission made by Mr. So-and-so, learned counsel for the on the instruction submitted by the counsel for the respondent number 2, that necessary correction will be made in the notification. His writ petition was disposed of. So this present writ petition was not disposed of on time.
So you mean to say that the legality or otherwise of the SRD was not
in the judgment passed by a coordinate bench of this High Court has no binding before. What's and the appeal as a consequence of this order. And should the second ground. Lordship, from yesterday, all the counsel representing for the respondent, you are making a heavy submission on the ground that I have not challenged the basic cabinet memorandum. That is 2020 and 2022. Lordship, that's a repetition. If I see the 2024 cabinet memorandum, which is annexed at page number 142 in my page. Your Lordship, the aims and object of submitting this cabinet memorandum para 4. That is a proposal. The reasons of submitting this proposal. out of the initial to 259 posts, here are not 280, which are still in service. So from this, I want to, since Nagaland Public NBC has expressed difficulty in conducting the regulation exam, and since the committee has commitment has been made by the government for subsequent regulation of your service at the time of appointment during the pandemic, the following are proposed for consideration of the cabinet. From the report of this memorandum, it shows that since there was a failure on their part after the Nagaland Public Service Commission declined to conduct a special recruitment drive, this proposal was submitted. That means the earlier approval which was accorded in the year 2020-2024 now has become redundant. I'm sticking to that.
The NPC had actually given clearance for the department.
Who is the NBC? What authority has the NBC to give the authority to the department to conduct a special recruitment drive? Even an executive under Article 162 of the Constitution of India has no authority to bypass the provision of the service rule. That is a judgment which I placed yesterday.
That's why they are relying on the extraordinary circumstances.
The extraordinary situation cannot override the provision of asset rules.
We'll see.
And third sponsorship, the locus the petition has no locus to file the present petition since we were just a student during the time of issuing the advertisement. As I've shown yesterday, as per the appointment order, the appointment order clearly shows that you were appointed on contingency basis for a period of 12 months, subject to be regularized through the Nagaland Public Service Commission. They are not holding a regular post. Awesome. So the posts held by them are still open. I'm just reading. So we have the locus to challenge the present inbuilt cabinet programs. And Lordship, we are also heavily relied on the grounds that a policy decision is not subject to judicial review. Lordship, in the present petition, we are challenging a policy decision which was taken in violation of the provision of the service. As statutory rule has been violated by this decision, so it is always open to judicial review. Even the citation of 2016, which my learned senior brain city has just read, the last 2016 judgment, they also state when the statutory rules are violated. So that judgment is in support of me. I'm not relying on any judgment. And lastly, she may kindly come to the state government like that. Paratian, the last part.
Paratin.
It was a submission of the State Council that considering the surplus service rendered by the COVID-19 appointees, the department has taken the decision to regularize your service through departmental selection committee. Regarding the surplus service rendered by the COVID-19, may not read the para 10. That we regard the same way in paragraph 6. The deponent does not deny the fact that regular recruitment of medical officers should be done in accordance with Nagaland Health Service Rule 2006 to the Nagaland Health Service Rules Amendment 2017. However, the deponent says that due to the unprecedented situation faced by state on account of COVID-19 pandemic, coupled with shortage of medical doctors to tackle the situation, the state cabinet created various category of posts, including the medical doctors. It is the policy of the government to regularize the services of 83 out of 168 COVID-19 appointees doctors and 15 in-service contractual doctors who had rendered the selfless services during COVID-19 pandemic by risking their lives for the risks by special recruitment drive by relaxing the recruitment rules as a one-time dispensation. By relaxing the recruitment rules. Lordship, as I've submitted yesterday, I've placed a judgment passed by the Honorable Supreme Court in the year 1998. If the rule just by a decision taken to relax the rule, that will not obliterate the rules unless the rule is amended. Lordship, as on date, the rules of 2006 is not amended. Unless the rule is amended, the cabinet cannot take this decision. Lordship, this is just a one-page judgment. But that is a settled law.
The one you referred to.
1998. That is a settled law, which is still followed by all the courts in India. If the rule is amended, I have no say. But unless the rule is amended, we cannot resort to this extent.
And it is just 1 minute. On the last judgment which my learned friend is submitting on the question of amendment. In that particular case, we said there was a proposal to amend the service rule. And on the proposal of the, and on that proposal, without amending the service rule, the government acted upon it. And that was challenged. So the Honorable Supreme Court says, without, just because there is a proposal, the rule is not obliterated, and on the basis of the proposal, without actual amendment, they cannot act. In the present case, the matter relates to an extraordinary situation where the rules were relaxed. It isn't a question of amending the rule, rules were relaxed. So amendment, relaxation of the rules are two different subject matters.
One part of the rule has been relaxed, the other has been modified. You are not just notification.
Yeah, Mr. Lordship. Yes, Lordship. Lordship, in fact, I'm not appearing in this present case. I'm in another case, with the dental doctor's case. But this, the judgment that relied by my legislative counsel, the dental doctors, where the 3 posts, 5 has been segregated.
Yes, you made the submission. Yes.
I made the submission. Lordship, going by the cabinet decision, only 3 posts of dental doctors were created during COVID. But because of the exigency of the service, 2 resultant vacancies were also included in the dental doctor's case. So the repetitioners, they challenge that no, this has to be done through the service rule, recruitment. So a submission was made before the court that there was an inadvertent error on the part of the government by including the 2, making it 5. So that was rectified.
It should have been only 3.
Only 3. So what my learned friend is submitting is totally on a different line portion.
No, what he's saying is that the legality of SRD was not gone into by the court.
Yes,
That's what I
then
wanted
in
to
the
say.
division bench, Lordship, the appeal, the read appeal, it speaks about the SRD, Lordship, which my learned senior counsel has relied for respondent number 19 to 101. The read appeal number 5 of 2024. An appeal was preferred. Lordship, the first read petition was filed by the unemployed dental doctors. The appeal was filed by those who were appointed during COVID. That it should be 5. Lordship, may kindly see the party name, they're different. The writ petition was filed by Dr. Tumbeni Pinguli and 14 others. The writ appeal has been filed. Lordship, may kindly refer to the list of.
Yes, WPC is Tumbeni Pinguli.
Yes, and 14 others.
The appeal is Dr. Lingam Kongyak.
Yes.
2 others.
Yes.
The appellant would not the party in the writ petition should give the leave to appeal before this rule. In the leave of the appeal was allowed. After the appeal was
Yes. Now, those who filed the appeal were those who were appointed during COVID. There were 5 of them. They challenged the legality of this order, the single bench, saying that it should not be segregated. It should be 5. It has been clearly
distinguished lordship. And it's been clarified with regard to SRD also. Four notices. Starting from paragraph 4 of the read appeal lordship.
Yes, yes.
The whole issue of SRD has been explained. From 4 onwards, lordship. My learned senior counsel has already read out the whole judgment.
Yes.
So I might not
Yes,
be.
it was discussed.
Yes, that has been discussed. So the legality of SRD as raised by my learned friend lordship, that has been cleared. And this has not been challenged. And this judgment has attained its finality, lordship. The legality of the SRD, they cannot question now. And besides this, their lordship, there are some another 5 judgments where the legality of the SRD has been upheld.
By this court.
Yes. I never anticipated my learned friend counsel will go to that extent of questioning the legality of the SRD. I can produce those judgments, lordship. Because
you can submit later.
yeah, fortunately, I appeared in all the cases where the court has upheld the legality of SRD. Because those writ petitions were filed by those COVID appointees saying that no, our appointment should be regular because we have gone through a recruitment process. But we said no, cabinet has taken the decision for SRD. So SRD is meant for those who have served and appointed during COVID. I can.
Yes, yes, you can supply later.
Yes, lordship. God bless you, lordship.
That's all. Yes, yes. So now.
Lordship, in 307, the research scientist, kindly give me the.
Yes, yes.
Kindly grant me 5 minutes. In 5 minutes, I'll cover because it is simpler.
Okay.
Exactly like. I'll take only 5 minutes.
That one is WPC
307,
307.
2024. Lordship, the position of there are 5 petitioners before this honorable court. 5 research scientists. Their position is exactly like respondent number 90 to 101 on the issue, but the only difference is in the present, the first petition in 1
minute.
Service suit. In the with regard to the research scientists, there is no service rule. That is number 1. Now, Lordship, can you come to page 40 to the writ petition? That is the same advertisement.
Page 40.
Yes. We have referred in the earlier case also, but just to show.
Yes.
Then Lordship, we can see research scientist, serial number 3, 6. Serial number 6. Serial number 3.
Serial number 3,
Yes.
6 posts.
6 post. Lordship, then Lordship may come to page 23.
Yes.
Kindly allow me to read. As approved by the cabinet by memorandum dated 25/6/2020. Lordship, you have already referred to this cabinet memo. For creation of post engagement on temporary basis in reference to recommendations submitted by Directorate dated 4/11/2020 and with a view to effectively tackle the present pandemic 19 in the state in interest of public service, the Governor of Nagaland is pleased to engage the following persons as research scientists. Lordship, the respondent petitioner is starting from 2 to 5. Petitioner serial number 1 is not before this honorable court. The other
2, 3, 4, 5,
3,
6.
5, 2, 3, 4, 5, and 6 are there. Lordship, the decisions thereafter, Lordship, the cabinet memorandum of 2020, which is at page 32, is same for us.
Yes.
Then Lordship, at page 34, the cabinet decision of 11 June 2024 is also, Lordship, same for us.
12 June.
Yes. Then page 36. Lordship, page 36, 25th, 23rd June 2020, as serial number 6 is the creation of the 6 posts, by which then Lordship, at page 38, page 12, annex 12, serial number 5 is the creation, exactly along with others. Then Lordship, at page 47 is the cabinet memo, which we have referred. Lordship, then Lordship, at page 49, serial number 10 is 10, the 6 posts of research scientist. Then, my lord, at page 51 is the same for all of us. And then Lordship, the MO, then Lordship, the 2 letters of the NPSC, which is 54 I have mentioned. Then Lordship, the letter, then 57 is the second NPSC letter. Then Lordship, the cabinet memorandum of 2024 is at page 59. Lordship may kindly see at page 60. Page 60, Roman 5. Permission may be granted to recruit 4 categories of posts that are yet to have service rules, since it would be unfair to leave them out. Subsequently, the service condition will be subject to the provisions of the rules as and when framed. That is with regard to us, Lordship. Then page 61 is the one which is challenged in the other case. Lordship may kindly take note of the fact that in the other case, in doctor's case,
239,
239, the challenge is only with regard to the medical officers, not to the remaining services.
Yes, only medical officers.
Yes, medical officers were challenged. Interim order was also only with regard to the medical officers. So as on today, nobody has challenged this 2024 or any of the 2020 cabinet decision, 2022 and 2024 with regard to research scientists has not been challenged or not raised a stay. So, my lord, that distinction can be kept in mind, because it should not be clubbed up with other doctors. With doctors, challenge is specific for them only. Then, Lordship, page 62 is a decision of the government for administrative approval to conduct the exam. Then at page 63, Lordship may kindly see is the calling letter to be issued by the director. At page 64, Lordship may kindly see the names of the petitioners. At page 64. The 1, 2, 3, 5, and 6.
1, 2, 3, 4, 6.
Then Lordship, from page 66 to 70 are the admit card issued to us. And Lordship, we have challenged page 71. My lord, the 5 copies is also on the next page, but matter regarding special recruitment drive. With reference to the subject cited above, I am directed to inform you that the proposed special recruitment drive may be deferred for 2 weeks. This is for information and necessary action. This is the immune letter dated 23rd August 2024. It was deferred by 2 weeks, but since then, they decided they have not conducted the exam. That is how we approach this honorable court, challenging this letter for deferment.
So you're only for this?
Because Lordship may kindly see
against the deferment. Let's see.
Challenge this in a direction, Lordship, for time bound.
We should set aside 23, 8.
Page 19,
Written and
Lordship, can you see the
one-time
prayer?
dispensation of special requirement filed to- Okay, okay. Mm. So your only prayer is that time-bound direction should be given?
Yes.
For this.
Because Lordship, as on today, nobody has challenged the policy decisions with regard to the research scientists.
Yes.
2020, 2022, 2024. So that is a distinction between the doctors in the present case. So there is no legal impediment for us. Lordship, may kindly see the affidavit of the government. I'll only read one.
Dated 23/8/2024.
My lord,
Wait.
yes. Lordship, paragraph 7, page 6. This is the only wrong because paragraph 1 to 6 is in support of the petitioner because they have supported the policy. So, my lord, to save time, I'm not reading Lordship paragraph 5, 6, 5 and 6.
Paragraph 5 and 6. Then which is the relevant?
7.
7.
May I read, Lordship?
Paragraph 7, yes.
May I read, Lordship? That with regard to statements made in paragraph 6 of the writ petition, the answering the categories submit a special requirement for all categories of posts, including the posts held by the petitioners as research scientists, were opposed by the student bodies through media, and series of meetings were conducted to resolve the issues. According to the department, by the letter dated, direct to defer a special recruitment. By a letter dated, the special recruitment was deferred to 2 weeks. Mentioned to be met at the writ petition has been filed challenging the regularization of COVID appointees in 187 and 239 for the post of medical officers and dental doctors. And accordingly, in view of the different of regularization, the Honorable Court had directed not to follow the regularization of COVID appointee through the departmental screening committee. So this is the only, because in view of the interim order passed in the other cases, he decided not to go ahead with us for our exam and the pressure from the student bodies. Otherwise, Lordship, if you Lordship may kindly see at paragraph 5 and 6, I will not read that. It is in tune with what my learned friend has submitted in the other case.
In that case, Sucre, can it be disposed of, this one, in fact?
Yes.
Because you can only separate it, because this will be a different board, I'm sure. Because for research assistant, research scientist.
But I think if you see at page 59 of the writ petition. 59 of the writ petition.
Yes.
Paragraph 4, Roman 2.
Roman 2, yes.
The 280 posts of COVID-19 appointees also include regular vacancies. Here, the petitioners comes under the 280 posts, which is proposed for special recruitment drive. And the special recruitment drive, this only was for which we have earlier concluded. So, though interim order is not
in respect of
but in the interest of the department also not to have any further complications.
No, because see,
Otherwise, I leave to your lordship.
because research scientists, because even the exam, the manner will be different, because the board also will be different, because for this, again, they need separate board, I'm sure, for research scientists, not the medical, for the medical doctors, not the same board.
Because
qualification is different.
We are the doctorate in biotechnology.
Yes.
Masters in, so the nature of work, everything different. And nobody is challenged.
Yes.
Nobody is challenged.
And no interim.
The present petition, uh, under Article 226 of the Constitution of India has been filed by the petitioners praying for a direction to the respondents to conduct the written and viva voice of viva voice under the special recruitment drive for 5 posts of research assistant, research scientist, as approved by the letter number HFW under bracket A 10/34/2024/215 dated 28/2024, issued by the Joint Secretary to the Government of Nagaland Health and Family Welfare Department, and the letter number DHFW-1-SRD/663/2020/7892-94 dated 21/8/2024, issued by the Principal Director, Directorate of Health and Family Welfare, Nagaland, within a time-bound manner. Stop. Para. I have heard learned senior counsel for the petitioner, Mr. Takamasa, assisted by Mr. Santi Long for the petitioners, as well as Ms. V. Shukri, additional AG for the state of Nagaland. Stop. Para. The case of the petitioners is that they are presently serving as research scientists under the on temporary basis under the Directorate of Health and Family Welfare. Stop. The State Cabinet vide Memorandum Number CAB-2/2013 dated 31/3/2020, Memorandum Number CAB-2/2013 dated 1/6/2020, Memorandum Number CAB-2/2013 dated 12/6/2020, and Memorandum Number CAB-2/2013 dated 25/6/2020 had created 280 posts of medical officers, dental surgeons, nurses, etc., including 6 posts of research scientists under the Department of Health and Family Welfare during the COVID-19 pandemic. Stop. It was notified by the notification number HFW under bracket A COVID-19/APPT-13/17/2020 PT under bracket /263 dated 2/7/2020. Stop. The cabinet had also decided to relax the rules, relax the recruitment rules to conduct a special recruitment drive to meet the COVID-19 pandemic emergencies to the aforesaid post. Stop. Thereafter, a special recruitment drive was conducted for appointment on temporary basis. Stop. The petitioners were appointed under this appointed during the COVID pandemic by the order number HFW under bracket A COVID-19/APPT-13/17/2020 dated 21/12/2020. Stop. And they are still continuing on temporary basis till date. Stop. The State Cabinet, by its meeting held on 25/5/2022, had further decided for relaxation of the recruitment rules for special recruitment of healthcare workers who had served during the COVID-19 pandemic on regular basis, vide number CAB-2/2013 dated 26/5/2022 through the NPSC and NSSB. Stop. Accordingly, it was notified by the notification number HFW under bracket A COVID-19/APPT-13/17/2020/543 dated 2/11 2022. The State Cabinet, by another decision, vide number CAB-1/14/2023, dated 7/8/2024, had further decided for relaxation of earlier approved procedures for regularization of service of COVID-19 appointees through a departmental screening committee. Stop. Accordingly, administrative approval was granted by the letter number HFW on the bracket A 10/34/2024/2015 dated 28/2024 for written examinations on 26/8/2024 and viva voice on 27th and 28th August 2024. Stop. The petitioners herein had also accordingly received their admit cards to appear the special recruitment drive. Stop. However, by the impugned letter number HFW on the bracket A 10/34/2024/441 dated 23/8/2024 and the impugned letter number DHFW-1-SRD/663/2020/7938 dated 24/8/2024, the aforesaid exam was deferred for 2 weeks without any reasons. Stop. The petitioners being aggrieved is before this court, praying for a direction. Oh, you had also submitted representation. No, stop. The petitioners had also submitted a representation. However, there has been no positive action by the respondents till date. Stop. It is also stated that there is no service rule governing the research scientist and their service conditions are covered by the decisions of the State Cabinet and the administrative decisions taken by the state government accordingly. Stop. Next para. Being aggrieved, the petitioners are before this court seeking for a direction to the respondents to conduct the written and the viva voice of the special recruitment drive for 5 posts of research scientist as approved by the State Cabinet and communicated by the letter dated 28/2024. Stop.
Sorry for intervention.
Yes.
6 posts was approved, but 5 petitioners before the Senate.
Okay. So they have also advertised 6 posts, isn't it? Yes.
But 5 before the Senate.
Special recruitment drive for 6 posts of research scientists as approved by the State Cabinet, such dated 28/2024. So the case of the petitioners is that the advertisement of the 6 posts of research scientists right. Where is the advertisement? 14, The advertisement of the post of 6 posts of research scientists, wide advertisement dated 4th August 2020 is not under challenge by anybody. Stop. In the affidavit in opposition of the state respondents, it is mentioned that writ petitions have been filed challenging the regularization of COVID-19 appointees in WPC 187 of 2024 and WPC 239 of 2024 regarding the post of medical officers and dental doctors. And wherein interim orders had been passed staying the interview process by this court. Which order do you remember? but the interim order in the other cases? By,
In the C number, by,
Uh.
dated 21/10/2024. Court order dated.
okay, by interim order, by this court, dated 21/10/2024.
First in WPC two.
In WPC 239 of 2024. Stop.
The doctors are not that, so I will.
Anyway, and therefore, the state respondents had not. Therefore, the state respondents had deferred the special recruitment drive for the research scientist. Stop. Para. Upon going through the pleadings and also the facts and circumstances in WPC 187 of 2024 and WPC 239 of 2024, stop. It is seen that the challenge is only regarding the advertisement for the post of medical officers and dental doctors.
And the policy decisions.
And the policy decisions made by the state government. No, but wait.
Lordship,
I'm just thinking if the court allows this special recruitment drive, then it will mean that the
Lordship,
other is.
I'm making a submission.
Ah.
I'm making a submission. there.
Yes.
Many other means.
Ah.
Because there is a distinction. In the other two cases, there is a service rule.
Here there's no
There is
service rule. Yes,
So
yes,
my
yes.
respectful submission all along. was
Right,
different.
right,
There is
right.
no service rule.
Hmm.
We are bound by the cabinet decisions and the.
Different
orders,
administrative
and which
orders.
has not been challenged.
Yes,
Lordship has
yes,
made a line
yes,
submission
yes,
that
yes.
the. Lordship has only made a
Ah.
submission
Yeah,
that.
that's the point, that you don't have service rules.
Yes, so my submission is that in view of the fact that there is no service rule, we are governed by the policy decision of the cabinet. And the advertisement and the policy decisions and the administrative instruction has not been challenged by anybody. It is holding the field. That's how it is distinguished.
Yes. Did I say about that there's no service rule, that petitioner has stated that there's no service rule and all? We have stated, na? Just so now.
But
coming
my
to the-
submission, it was only recorded that only advertisement is not challenged, only that much. So there, that can be.
Okay, there you can say the policy decisions before that, na? Where I said that the advertisement has not been challenged, you just add one line saying that the policy decisions made by the state cabinet as well as the various administrative instructions made subsequently have not been challenged, as well as the advertisement, no, has not been challenged. Yes. So now here you come to the last line. What did I say? Please notice that medical have been challenged on the ground that the service rules have been violated by the said administrative orders and policy decisions. Stop. However, in the present case, it is an admitted position that there are no service rules concerning governing the service of the petitioners. Stop. And accordingly, the various policy decisions and the administrative instructions / notifications will govern the services of the present petitioners. Stop. In view of this observation, it is the view of this court that there is no impediment. There is no impediment for the state respondents to conduct the interview in respect of the research scientist. Stop. Accordingly, the impugned the two impugn orders, no, which we said earlier, the two impugn orders are quashed and set aside, and the state respondents are directed to conduct the interview / conduct the written and viva voice for the 6th post of research scientist. How much time? 1 month?
1 month is sufficient because.
Yes.
We conducted.
Uh-huh. Yes.
August last year,
Within a period of 1 month
from the date of.
from the date of this order.
Much of it.
Receipt of the copy of the judgment.
Okay,
Otherwise,
from the
one
date
month.
of receipt, from the date of receipt of a copy of this order.
My lordship, make it 2 months. Make it 2 months, because 1 month may be quite close. 2 months.
One
may be
months.
Reasonable.
Because.
Two
Notice, admit card has been issued already. Everything is prepared.
No, it always has been kept on abeyance, so. 2
Because
months
it
will
was-
be-
Okay, 2 months, let it be
Yes.
2 months,
Gotcha.
yes.
Much.
Noted my,
Then what
my
about,
cases offers of.
yes, yes, sure. Then do we have one more, 184?
This petition, one.
So this is segregated.
One at four, don't you?
184 is there, yes. Who's
That's
ap-
the question is 70.
Who's appearing in 184?
I agree.
Oh,
Uh,
why is 184 also tagged along?
I don't know, Lord, should not have been that allowed. Yes, but because of this, COVID situation, because we take a run.
Who's appearing for the
No,
government?
There is none from the opposite side to one. So my lord, lady, she may take up a 157.
It's a very short matter here, Lordship.
But when the other side is present.
In fact, even before the filing of the other petition, I was the one who approached this court because of this COVID problem. And I was busy. I'm sorry, Lordship, I'm a.
You're talking about 184, nah?
I'm a dental surgeon, Lordship. And because of the paucity of time while approaching this court, I would have.
Acha, what about 187? Who's in 187? Oh. Acha, so 184 is someone else. Government.
I think I'm for the national health mission.
In 184.
Yes, just because he is working under my mission, I've been included in the party. In fact,
Oh.
it pertains to SRD.
Mhm.
His issue is, Lordship, he served during COVID. And he has been left out in the SRD.
Oh.
Lordship,
I see.
the issue involved is in 3 posts.
Mm.
SRD to be conducted, who will be eligible for the post. Now.
No, in that 280 post, is his post also there?
Dental, in the dental.
Dental.
So in the 3 dental,
Mm.
shortlisting was for 5 candidates
Mm.
who were appointed during COVID.
Mm.
He's saying, I served during COVID,
Mm.
so why I been left out? Before COVID also I served.
Mm.
During the COVID I have served. Thereafter I am serving. So why left me out?
Acha. Okay.
It's I have not met any.
So that is the different,
Also.
actually, it should not have been
Yes.
together.
Ultimately, the validity of the assignment has been put, yes, in that, the policy number, 239.
No, but then in that 280 post, his post was not included, that means.
No, it's included. 3 posts of that. He comes under the category of the dental doctors. Lordship, they are all together. They are different category of posts.
Then Sukre, why you're saying that other party is not there? You were saying that,
Something like that, once.
oh, okay. So,
Once in a year.
so you don't have the brief. Oh, oh,
In the issue, once.
oh. Acha.
The issue.
Then in that case, WPC 187, can we take it up? Then this one, let's take it up tomorrow. If MT is coming, that is. No, there's no DB. No DB. No DB. MT will be around.
In one occasion, they appeared.
Okay. Because we might as well take it up together, no? So tomorrow we
But,
can,
I think some is not parties available also. All this, since this all pertains to SRD.
that's why they were all tagged together.
Yes.
But here, actually, some separate instructions are required. Why the post was not included, why his name was not included? I mean, so for that
So in
separate,
fact, he's agreed by the 7 August 2024 cabinet memorandum. 6 August. Whereby the government has.
no, that I understood, but then that's why I'm saying government, the advocate needs some instructions again for that. It cannot be covered by the instructions in those other cases.
But in the next case, 187, he's questioning why I've been left out. So if 187 is decided, then ultimately.
Acha, 184 also will be covered.
Yes. So they can argue together.
Then let's hear 187 then.
Wait, please, your lordship.
Yes.
The lordship, I'm questioning as rightly pointed out.
Can
why-
can we start at 2? It's nearly,
Oh, my lord.
yeah.
Your lordship.
That is that they are undergoing, though they were appointed during the COVID time, they resigned. They did not apply for or start
We cannot have different category provisions.
Yes,
Yes,
Your Lordship.
yes.
And my lord, in this case, we are those who were appointed during the COVID-19. During the peak COVID-19, advertisement was issued for recruitment
Yes.
and we were recruited. And after
Oh, you
that,
also appeared and you were recruited.
yes, Your Lordship. Initially, there were 16 petitioners. Now, 10 of them, they did not want to pursue anymore, only 6 remains. Basically, just one line explanation for my lord's understanding is the condition for this special recruitment started after the government of India's letter, which is not in my writ petition, but has been.
Yes, yes, we have seen.
Now, going by the decision of the state respondents, the condition for participating in the special recruitment drive is whether we have served for 100 days. And the condition of the advertisement under which we were appointed is to apply for further study leave, we have to be in the job for at least 2 years. All of us have served for more than 2 years, regardless of whether we have resigned or we left the job voluntarily to seek for further studies. And in fact, going for specialization further studies, it is good for the state. It is good for the citizens also, Your Lordship. So, my lord, unfortunate that without any other document reliance, it is just a submission of the state respondents that since we left the job and we went for further studies, we are not eligible. Not even a single document is there to show that those who went for further studies are not eligible to apply in this special recruitment drive, Your Lordship. So, my lord, on that strength, basically that is the case, my lord. As simple as that. On that strength, kindly give me the additional document. My lord, when the letter, not even a notification or memorandum of order, but a letter was issued, and along with the letter, so many names were selected. I mean, in pick and choose manner, in which we were left out, my lord. And only few days time was given. Only few days time was given to apply for to appear in the examination. So in a rush, we filed this writ petition. In just a matter of 2 days, They came all the way from outside Nagaland.
Mm.
And then filing this writ petition, they did not have the copy of the advertisement.
Mm.
So my lord, some explanation have been made in the additional affidavit, but lordship, before going further, I may be allowed to rely on the advertisement, which is a page in the additional affidavit, my lord. Additional affidavit filed by the petitioners. Has my lord found it?
1 minute, okay. Now, all the pleadings are mixed up. 1
No, no.
minute.
Your lordship. This is 187 of
Yes.
2024.
And what?
Additional affidavit.
Yes, I don't know.
My lord,
Yes.
in the, I have prepared the subject index and list of dates also.
Mm.
So number one, serial number one is additional affidavit on behalf of the petitioners.
It's additional affidavit.
For easy reference, I usually prepare a subject index for the affidavits also, my lord.
Mm. Yes, filed on 5th September 2024.
My lord.
Mm.
So additional affidavit. My lord,
Yes.
may I take a lordship to page
Mm.
34? This is the advertisement. Page 34. This is annexure 33, in continuation of the writ petition.
Yes, this one we have already seen.
But the last page, your lordship, what I want to show to your lordship is a page 14, the last page. The last page of the additional affidavit.
Mm.
Conditions. May I read, my lord?
Yes.
Other conditions, serial number 4.
Mm.
The following conditions will be obligatory for all selected candidates. A, shall not be entitled for study leave for a period of 2 years. That is the most important, your lordship. Then shall serve in any part of the state as assigned by the department, shall sign a bond not to engage in private practice. All those are not relevant as far as the present submission is concerned, my lord.
Mm.
Because it is the stand of the state respondents that we resigned or left the job.
Mm.
And the second point taken by the state respondents, the stand taken by the state respondents is that by the 6th August 2024 cabinet memo,
Mm.
all conditions were relaxed, which means we were also left out. That is their stand. But which document says that we are left out is the question, my lord. So the condition is that we shall not be entitled for study leave for a period of 2 years.
Period of 2 years.
Yes, your lordship. Then, my lord, may I take a lordship to the same additional affidavit, my lord?
Mm. Yes.
Paragraph 3, my lord, at page 2. Paragraph 3.
Mm.
That the petitioner number 1, Dr. Abolo N. Yepto, has served the respondent department on active service pursuant to his appointment via notification dated 27th May 2020 till the month of December 2023. So, my lord, it is more than 2 years, in fact, more than 2.5 years.
Mm.
Then these are only the remaining petitioners, your lordship. The petitioner number 7, Dr. Vetrutol Cho, has served the responding department on active service pursuant to his appointment via notification dated 27 May 2020 till the month of September 2023. So this is also more than 2 years, my lord. Then next, my lord, petitioner number 11, Dr. Ilikalia Chumi, has served the responding department on active service pursuant to her appointment via appointment order dated 12 November 2020 till the first week of September 2023. That is also more than 2 years, my lord. The petitioner number 14, Dr. Im Jung Ban Nuklang, has served the respondent department on active service pursuant to his appointment via appointment order dated 12 November 2020 till August 2023. That is also more than 2 years, my lord. Then, my lord, the petitioner number 15, Dr. Tonoto K. Yepto, has served the respondent department on active service pursuant to his appointment via appointment order dated 17th May 2021 till the month of September 2023. My lord, that is also more than 2 years. Then the petitioner number 16, Dr. Hito Jakalu, has served the respondent department on active service pursuant to his appointment of, my lord, there is a typo, it should be his. Pursuant to his appointment, void appointment order dated 17th May 2021 till December 2023. That is also more than 2 years, my lord. So all the petitioners have served the department for more than 2 years. And if they have served for more than 2 years, this is very important, my lord, because 2 years is the limitation for them to go for further studies. So all the 6 remaining petitioners, they have served for more than 2 years, my lord. Then, my lord, if I may take a lordship to the main writ petition. May I take a lordship to the prayer portion? Despite the fact that the 6 August 2024 cabinet decision is quite vague, it only says that the procedures are relaxed. But we do not know if there is any other document in addition to this cabinet decision. That's why we have challenged this at prayer A, my lord. Direct the respondent number 1 for modification, amendment, or alteration of the cabinet decision dated 6 August 2024 in respect to the COVID-19 appointees to accommodate the petitioners to participate in the special recruitment drive. So we're asking for either modification or amendment or alteration, my lord. We have challenged to the extent that we should also be included. Then B, my lord, quash and set aside the letter number such and such dated Kohima, the 20th August 2024, issued by the principal director denying the opportunity to the petitioners from participating in the special recruitment drive. Now, my lord, via letter, and along with the letter, my lord, there was a list of candidates who are to participate in the special recruitment drive. We were left out. And prayer sees that we are requesting this honorable court to direct the respondent number 4, that is the principal director, my lord, to prepare a fresh list to include the petitioners in the list to participate in the special recruitment drive. Oh, my lord. Shall I take your lordship to the appointment orders?
1 minute, 20th August 2024.
Or shall we directly go into the relevant portion of the memorandums?
No, we have already seen the memorandums. and
Yes, but a
everything.
specific portion only, my lord. I'm not going to read everything,
Okay,
which
okay.
is relevant to us.
Let's see.
Your lordship. Then may I take your lordship to the first memorandum, letter dated 22nd May 2021 at page 27, my lord. Page 27 of my writ petition. This is a letter and type copy, your lordship, is at page 30.
Okay.
I will not read, my lord, but this is
Page
a letter written to the principal director from the principal secretary, in fact, the chief secretary, my lord, to grant additional incentives for healthcare workers involved in COVID-19 duties. So, my lord, pursuant to this, the office memorandum dated 27/1/2022 was issued. Now, this is starting from page 33, my lord.
27.
Page 33.
Okay.
This is specifically with regard to RIMS Imphal, your lordship, but why I'm relying on this is because it is also applicable to us, even though we are not studying under RIMS Imphal. This is, my lord, on page 33.
Yes, page 33. In next
Yes,
six.
that categories of candidates. A. For the purpose of selection for sponsorship under this OM, Category 1 will comprise of candidates from amongst the regular in-service officers of the Nagaland Health Service. 2. Category 2 will comprise of serving contractual officers under the state government, including those employed on contractual basis under NHM, NSEX, NHAK, etc. Lordship. So that also covers us, my lord. Then may I take your lordship to the next page, page 34, C, terms and conditions. Terms and condition 2, my lord, 2. The government of Nagaland will not extend any financial support for the expenses incurred during the study period by category 2. The 3 were not concerned, my lord. So we're the category 2, as my lord, reading with page 33, category 2.
Yes, yes.
And this.
That's
since-
serving contractual officers.
Yes, your lordship. So we have served for more than 2 years. Even otherwise, my lord, we are not covered by the sponsorship of the state. But it does not mean that we cannot take part in the special recruitment drive, my lord. Then, my lord, if my lord may kindly allow me to refer to the cabinet memorandum dated 13/5/2025, starting from page 35, my lord. Is my lord on page 35?
35 is
35, annexure 7, para 3, my lord. Paragraph 3 of the office cabinet memorandum.
further.
Further, yes. Further, with a view to increase availability of healthcare workers for performing COVID-19 duties during the second wave, the government had also announced additional incentives for healthcare workers involved in COVID-19 duties, give preference in the form of up to 25% of the total marks for the respective recruitment examination, depending on the length of COVID duties rendered to healthcare workers who have worked on COVID-19 duties in the government or private also, my lord. My lord, may kindly appreciate this, including private also, not just government. Private COVID-19 facilities for at least 100 days, for appointment against the regular government post for any post recruited through NPSC, NSSB or Department Recruitment Board during the year 2021 and 22, paragraph 4B, letter number so and so. So, my lord, it is not extended only to those who have served in the government establishment. It is extended to those who have served in the private institution also, your lordship. Then, my lord, may I request your lordship to kindly turn to the next page, page 36. Roman 3.
Roman 3, yes.
Roman 3, the next page, page 36. Contractual employees engaged by the government, including in NHM, NSEX, NHK, etc., who had resigned during the course of COVID-19 pandemic. So those who resigned during the COVID-19 pandemic, they are the ones or refuse to accept the contractual engagement shall not be eligible for any weightage for rendering COVID-19 services. So, my lord, here is a case where we have never resigned during the COVID-19 pandemic, your lordship. We have sacrificed equally like any other candidates who have been in a pick and choose manner have been selected to participate in this special recruitment drive, your lordship. Then, my lord, other issues like the writing to the NPSC and then the NPSC writing back, those things have already been referred to, your lordship. So, my lord, coming to the cabinet decision dated 6th August 2024, if I may be allowed to take your lordship to page 47.
Yes.
Your lordship, the last additional agenda and the last paragraph, my lord. Regularize agenda number 3, regularization of service of COVID-19 appointees through departmental screening committee in relaxation of earlier approved procedures. So it only says relaxation of early approved procedures. It doesn't talk about rejecting some candidates and pick and choose the other candidates, your lordship. The condition is whether we have served for 100 days during the COVID-19 pandemic. It is the examination process that has been relaxed, my lord. Because it was supposed to be conducted by the NPSC, but the NPSC refused. So the examination process has been relaxed. But at the cost of repetition, if my lord may allow me, it is not at the cost of pick and choose. The exercise in which the manner in which the state respondents have carried out. That page, next page, annexure 12 is also just this is 7 August 2024. Just showing the minutes of the 6 August 2024, my lord, of the cabinet meeting. Then, my lord, if my lord may kindly turn to page 49. This is the administrative approval. May I read, my lord? This is 20 August 2024, August 2024. To the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima. Subject administrative approval to conduct written and viva voce for one-time dispensation of special recruitment drive of the specific categories, 280 posts. Sir, with reference to your letter number such dated 9 August 2024 and on the subject cited above and as approved by the State Cabinet, that is 7 August 2024, I am directed to convey the approval of government to conduct written exam and viva voce of one-time dispensation of special recruitment drive of the specific categories, 280 posts of the engaged persons. So those who were engaged during the COVID-19, my lord. Necessary arrangements may be made for conduct of the exam in a free and fair manner at the earliest. So, my lord, the exam is expected to be conducted in a free and fair manner. But for those of us in the category who were engaged during the COVID-19 period, and we have served for at least 100 days, in fact, more than 2 years. So, my lord, if we have to count every day of the duties that has been performed in the period that we were in service, it is much, much more than that, my lord. For your lordship, it is my humble submission that regardless of whatever stand the state has taken in their affidavit, they have taken 2 stands. One is that we left the service. The second point is that by the cabinet decision, the interpretation of the state respondents by the word relaxed is that we are left out. But where is even a single document to show that those who have served for more than 100 days or 100 days during the COVID-19 pandemic, but have gone for further studies, either by way of resignation or voluntarily giving up the service and then our own higher studies, they should be left out. There is not even a single document, my lord. So, your lordship, a preferential and differential treatment, which is against the Article 14 of the Constitution, and my lord, discrimination is apparent on the face of the report itself. So, your lordship, respectfully, it is my submission that until and unless, if they have some other documents to show that since you have gone for further studies, you would be left out. If there is such document, I would have challenged, but there is not even a single document as such. On the strength of my submission.
When did you resign?
Your lordship, some of us resigned and most of us did not resign also. We just went for further studies because we asked for the permission, but then regardless of the very existing condition of our appointment that we should serve at least 2 years before we go for further studies. All of us have served for at least 2 years. We have passed the entrance examination. We sought for permission, but then permission was not granted. And further studies is good, not only for us, but for the people and the state also. Specialization is what we require. And the condition of appointment, the advertisement is that we should serve for 2 years before we go for further studies. We have all served for more than 2 years, my lord. And respectfully, your lordship, in this case, we were engaged during COVID-19. We have given more than 100 days of service. So, my lord, since we were engaged during that period, there is no question of leaving us out of this special recruitment drive. In an extraordinary circumstance, our services were happily utilized. Now, when the exam is to be conducted, they want to pick and choose some persons and then leave us out. As far as those who are selected, we are not aggrieved, but we should be included. And wrongful preferential treatment should not be given. We should also be given equal consideration. That is our stand in approaching this on the board for intervention, your lordship. May I rely on some authorities, my lord? I have made a brief note, my lord, for your lordship's reference of the principles of law, my lord. Your Lordship, the first judgment that I'm relying upon is the 2008 5 SCC 287. I'm relying on paragraph 18, my Lord. This is Satyawati Sharma versus Union of India and another. Paragraph 18, my Lord.
What is there?
May I read or?
It's okay, I'll read later, you just,
Yeah, okay.
yeah,
So
read this.
Yes, Your Lordship. The doctrine of reasonable classification and the principle of intelligible differentia should be applied when the question of equality is applied to persons or things similarly situated. The middle course should be adopted for realistic reconciliation. So, my Lord, here, even if I don't elaborate, my Lord has already got the thing.
Reasonable classification.
Yes, Your Lordship. So we are all in the same category. So when we have all served during the COVID-19 period for at least 100 days, preferential treatment should not be there. It should be given equal treatment. Lord, 2010 3 SCC 621, I'm relying on paragraph 17 and 22. This is Hariram and another versus state of Haryana and others. Test of reasonability in exercise of executive power must be fair and should not be arbitrary. Reasonable classification should apply intelligible differentia. There should be no discrimination within the same class or category of people, my Lord. And as far as the COVID-19 period policy is concerned, we're all in the same boat, my Lord. Then, Your Lordship, 1951 SCC 860. This copy, my Lord, may not have it, so I'm relying on paragraph 49 and 50. This is equality principle on the face, has no classification, and yet it can only hit a particular individual or a class of people. So equality principle should be applied according to the varying needs of different classes of persons requiring separate treatment. Now here, my Lord, why this judgment is, they are trying to give us a different treatment because we went for further studies. But if we go by the policy of the state itself, and even by the cabinet decision of 6 August 2024, which was notified on 7th August, my Lord, in fact, no classification has been made, because if any classification was made, there will be other documents also to say that we are excluded, but no such document is there, my Lord. Then, my Lord, I am also relying on 1952 1 SCC, which may not be available here, my Lord. Paragraph 6, 7, 46, and 47. So Article 14 is designed to prevent a person or class of persons from being singled out from others similarly situated. Varying needs of different classes of person often requires separate treatment. So, my Lord, here, why I'm relying on this is, for those who are in the service, they are in the service. But we have our condition of appointment itself is that we should serve for 2 years before we go for further studies. That is where we become different. Then, my Lord, 2008 2 SCC 161. I'm relying on paragraph 58, my Lord. Number 5. On legitimate expectation, my Lord. A legitimate expectation is different from anticipation, desire, and hope. It is based on a right, grounded in the rule of law, requiring regularity, predictability, and certainty in the government dealings. The doctrine of legitimate expectation operates both in procedural and substantive manners. So, my Lord, the facts of the case, or the face of the report itself, it gives us legitimate expectation, and on that legitimate expectation itself that we were in service, risking our lives, my Lord, and to be thrown out at this stage, it is against the doctrine of legitimate expectation. Then 6, my Lord, 2011 3 SCC 778, I'm relying on paragraph 24. The doctrine of promissory estoppel applies where the government makes a promise and the promisee acted in reliance of the promise by altering his or her position. Then, regardless of whether the same is recorded in the form of formal contract or not, the government promisor would be held bound by the promise. Why I'm relying on this, my Lord? Because even before completion of 2 years in service, we would have applied for further studies. But because the condition is that we should be in service for at least 2 years. So after serving for more than 2 years only, we went for further studies. Now the state is stopped by the promissory estoppel, my Lord. Then 2011 5 SCC 435, paragraph 11 and 12, my Lord. Law does not permit a person to both appropriate and reprobate. No party can accept and reject the same instrument, and that a person cannot say at one time that a transaction is valid and thereby obtain some advantage and turn around and say it is void for the purpose of securing some other advantage. Can the state respondents now go back and change the condition of our appointment, Your Lordship? They cannot do that now. After we have fulfilled all the criteria: 1, 2 years in service; 2, we have served for more than 100 years. Sorry, Your Lordship, for more than 100 for more than 100 days. After fulfilling all these conditions, now, my Lord,
But you left without any notice.
Your Lordship, some of us, in fact, we all approached the authorities informing that we want to go for further studies because our condition itself is clear that if we have served, the question is whether we serve for 100 days or not. That, my Lord, may kindly take note of very seriously. Did we serve for 100 days? We have served for 100 days, more than 100 days. And my Lord will also kindly appreciate this point. This 100 days is not only applicable to those of us, the petitioners who serve in the government establishment, identified private clinics for COVID-19, Your Lordship. They are also those who serve for 100 days. They are eligible to apply for this special recruitment drive, Your Lordship. It is by the document of the state respondents itself. Then, my Lord,
Anyone from private clinics also there in the list?
not
Private
even one, Your Lord.
hospitals.
Not even one. Then, my Lord, 2026 SCC, page 387. I'm relying on paragraph 26 and 27. A person who takes the benefit of a portion of a will cannot challenge the remaining portion of the will. So the same principle, Your Lordship. So, my Lord, here, when it is not only us, but by the document of the state respondents itself, that as far as eligibility criteria is concerned, not only us who serve in the government, those who serve in a private clinic are the identified, what is the specific terminology for private clinics? The identified private clinics during COVID-19.
Pieces of COVID. They have designated.
Oh, designated. Yes, Your
Designated,
Lordship.
some private
Designated.
hospitals.
Yes, Your Lordship.
Mm,
Yes, Your Lordship.
mm.
So those who serve in the designated private COVID hospitals also, they are also eligible to apply in this. And as far as the cabinet decision of 6 August 2024, which was notified on 7 August 2024 is concerned, my Lord, it relaxed the examination procedures. It doesn't say anywhere by way of supporting document, even in the affidavit of the state respondent, it doesn't say that some candidates will be preferred over the others. None of the private, those doctors who serve in the private hospitals, designated COVID private hospitals, none of them were also included. And despite the fact that we are fully qualified to apply for this special recruitment drive, none of us were also included, Your Lordship. So it calls, respectfully, Your Lordship, it calls for the intervention of this Honorable Court, and the petitioners deserve to be part of the special recruitment drive. The letter dated 20 August 2024, it deserves to be quashed, set aside, and a fresh list, including us, should be brought out, Your Lordship. And also the cabinet decision, though it's very vague. It doesn't say, it only says that the recruitment process is relaxed. But it's very vague, but as a measure of abundant caution, we have challenged that also, seeking modification, alteration, if any is required, Your Lordship, so that we will also be included in the special recruitment drive. And that is my humble submission, Your Lordship.
That is yes. Belong to petitioner number 2, 3, 4, 5, 6, 8, 9, 10, 12, and 13. They have withdrawn themselves from this case.
2, 3, 4, 5, 6, 8, 9,
10,
9, 10, and 12.
12, and 13. They have withdrawn themselves from this case. Only petitioner number 1, 7, 11, 14, 15, and 16 remains.
Okay.
Yes. My lady may turn to page 48 of the writ petition. This is the cabinet approval.
Page 1.
48.
48.
Yes, this is dated 7 August 2024. Minutes of the cabinet will be held on 6 August 2024.
1 minute, 1 minute.
Additional agenda number 3. Page 48 of the writ petition.
Yes. Minutes of cabinet meeting.
Yes, yes. Additional agenda number 3. Regularization of service. This is very important. Regularization of service of COVID-19 appointees through departmental screening committee in relaxation of earlier approved procedures. It talks about regularization. So when the petitioner are no more in service, where is the question of accommodate, including them for special recruitment drive? The petitioner never challenged this cabinet approval order.
It is challenge, Your Lordship.
No, this is not.
Prayer,
challenge.
Your Lordship.
This is only to include them only, to modify and to include. When the basic order is not challenged, they cannot challenge the subsequent. Here they have asked for modification, amendment, and alteration. On what basis? They have never pleased. Page 17 is the prayer. Direct the respondent number 1 for modification, amendment, alteration of the cabinet decision.
Modify,
Page
amend,
70,
alteration
para A.
of cabinet decision dated 6.
So without challenging the office memorandum to be illegal, they cannot ask for this court to direct the respondent to modify or to alter and to accommodate them in the special recruitment drive. So my lady, now when they are no more in service, the question of they served for 100 years does not arise.
100 days.
Yes, 100 days. 100 days does not arise. Because regularization precedes
No, they're talking about 100 days during COVID.
yes.
During COVID.
But we have extensively heard in the other matter where we have stated that the special recruitment drive is only for those in service medical doctors or medical health care workers, only in service. So when the petitioner, if the petitioner are still in service, their name would be included. But since they have resigned, some they have resigned, some they did not apply for extension, some they just left without the permission of the department and now undergoing PG course. So they do not have the locus to file this case. And my lady, may kindly turn to page 33 of the writ petition, where my learned friend has relied on this office memorandum, page 33.
Yes.
Office memorandum dated 27 January 2022. This does not apply to the petitioner because none of the petitioner are undergoing PG course under REAMS Infra. This office memorandum pertains only to REAMS Infra. In their pleadings in the writ petition, the petitioner has stated that they are not aggrieved for the regularization of the 98 medical officers. So, and they did not challenge the office memorandum or the policy of the government. So now they cannot come and obstruct the government to conduct the special recruitment drive. The petitioner is devoid of merit for not having the local standard. Number two, they are no more in service, so the question of regularization does not arise. And the special recruitment drive is only meant for in-service, only those who are still serving, not those who had resigned or who left. That's so the petition is liable to be dismissed. That's my humble submission.
Even in that notification of the post, Mr. Joshua, that this your annexure 9. Annexure 9, I think, yes. Annexure 9, page 45. It says on it's serial number 6. The allocation of marks shall be applicable only to those officer staff who are serving.
Which point, Your Lordship?
Page 45.
Your Lordship, at that point of time, we were also serving.
Who
Your
are
Lordship.
serving?
Yes, Your Lordship.
22.
At this point, we are all serving, Your Lordship. We left only in 2023, Madam.
23.
Your Lordship.
At this point of time, the special recruitment drive is to be conducted through NPSC.
At that point of time,
Yes,
yes,
at that
yes.
point of time. But by the lapses of time and the inability expressed by the NPSC, now the special recruitment drive is to be conducted through departmental, yes.
Let us just go through that latest one again. Where is it? The latest to 2024.
Page 49, my Lord.
No, this is only the administrative approval. The cabinet decision.
That is page 48, 47 and 48, my Lord. The latest. 47 and 48 of the writ petition.
No, not this.
Yes. The petitioner has not annexed in the.
It is not annexed.
So it's in my affidavit in opposition, page 34. Page 34.
Yes, this one. Let's just read this again.
Even point number 4. Out of the initial total of 329 posts, there are now 80 who are
We're still in service, yes.
This was never brought to our notice, Your Lordship, so.
I found my affidavit.
No, it is there,
Yes,
the
but,
affidavit.
But we have, of course, in the affidavit, we have already replied. And before filing, it was not brought to our notice.
From the very beginning, this cabinet memo itself, the policy decision was that it is for those who are still in service.
Then, Your Lordship, what happens to those? Of course, my learned friend is submitting now. I do not want to interrupt her, but just one question. What happens to those who are also eligible? That is, those who have practiced during given their service in the designated private COVID hospitals. They are also supposed to be eligible for this special recruitment drive, Your Lordship.
No, but as far as the court is concerned, we cannot go into that. That is outside the purview of the writ petition. Because here we are only concerned about this cabinet memorandum of 1st August 2024. Who knows, there may be another policy for people like you. You are still serving. No, but your case we're going to hear tomorrow. Okay, yes, and then?
Yes, so that's my period is that the petitioner does not make out any case, and the petition should ought to be dismissed.
Yes.
Your Lordship, we kindly appreciate this. My Lord, the documents which have been brought on record after filing of the writ petition, Your Lordship, there I cannot comment much on that. But Your Lordship will kindly appreciate this that the.
No, but you filed a reply also.
Yes, Your Lordship.
Reply to the counter.
Yes, Your Lordship. So basically, my ground is, Your Lordship, we want the intervention of this Honorable Court to interfere with the cabinet decision, Your Lordship. There is a difference between kill the person or reform the person. Here, if we say kill the person, then what benefit do we extract out of it? We want the same to be modified or altered, that is, in a form of reformation. That way we can also be included. That's why we have challenged the cabinet decision, not by way of saying that it should be quashed and set aside, because everything goes. If everything goes, what benefit do we ask from this Honorable Court? That's why we are asking for the intervention of this Honorable Court for amendment or modification or alteration to the extent that our sacrifice, we have made equal sacrifice, not just who are in present service, Your Lordship. Where do our sacrifice go? At a time when we risk our lives and we have equally performed the duties, my Lord, the extraordinary circumstance, it was not faced only by them. We left after the entire episode of risking your life was over, my Lord. That's the reason why we're asking this Honorable Court to interfere by way of directing the state respondents to amend the cabinet decision or alter it or modify, my Lord. That way we will also be part of it. If not, we could have challenged the whole process, but then that way we will not get any benefit. The Lordship may kindly distinguish the difference, and our sacrifice may kindly be honored by this Honorable Court, because we were in the front line, equally performing, risking our lives, like those who have been in a pick and choose manner, who have been selected, my lord, who have given equal service. That is my humble submission, your lordship.
See, where policy decisions are concerned, the court has a limited jurisdiction, okay? So whether the court can direct a government to frame a certain policy, that I don't think so.
No, my lord, the difference, my lord, is of course almost at the cost of repetition, though I'm trying to make it.
No, I've understood what you're
Yes.
trying to say. And the court has also understood your plight also. But then, like I said, in a policy decision like this, the court's power is very limited, actually. And
Lordship,
we cannot direct the court, the government, like you said, to reframe the policy or, add or minus or anything. No, the court is not an expert on that. The court doesn't have the expertise to decide. The government may have its own reasons
no, my lord.
to frame a certain
Yes,
policy. Anyway.
my lord, the lordship.
But I need to clarify on my another friend's submission that the 98 doctor, we have pick and choose. No, we have not pick and choose. These are the doctors
Who are still
in
serving,
service.
who are still in
Yes.
service.
They are still in
But in
service.
fact, the lordship, I think I had a name, but I do not know whether I have included in my petition or not. One who is on further studies also was included in that list.
He has to go and challenge that. He says that he
You
is
sure
not-
then if there is,
Your lordship, I can bring the name tomorrow and show you, lordship.
It cannot be. My lord, may kindly tell me.
Lordship is saying no.
Everything has been submitted. May kindly come to HR.
The judgment is not delivered yet, your lordship.
of course, it can be kept part-heard. But,
Only to produce the
May
name. your
kindly
lordship.
come to HR.
but again, when you produce the name, they have to verify, no? That
No,
will,
they know
that,
it.
that will take time again.
It is very much in their knowledge, your lordship.
Page 14
14 of,
the repetition. Para 24. Para 44, 24,
24.
second paragraph.
Yes.
Fourth from the bottom line.
Hmm.
Para 24, second para, fourth line from the bottom. While the petitioners,
Are not aggrieved.
yes, while the petitioners are not aggrieved by the 98 candidates, the petitioners are aggrieved for the non-inclusions of the
Of their
names. So
names.
your lordship say, when they are not aggrieved, how can he just raise that issue now? When he has admitted in his pleadings that he is not aggrieved for the inclusion of the 98 candidates.
Yes.
Your lordship, that submission, in my respectful submission, that submission cannot be accepted in isolation, my lord. We're saying we want to be included. So if we are.
Yes,
if we are
you're
asking
saying you want to be
yes, your
included,
lordship.
and the court has to confine itself to the prayer, your prayer. You're not challenging their inclusion.
That is because we also want to be included, my lord.
Okay. Any more? Yeah. Reserved.
Your lordship.
Albert, this one also, I need photocopy. This one is in that 239, okay? Yeah, I wrote 239 half and they do it. No, this one we said we'll hear tomorrow, na? Because Im Song is not there.
Not much time in this discuss of that.
No, but without the other side, because she's not appearing in this matter. That's why I've already said Passover, I think. Already Passover order is there. Tomorrow, you inform Imti.
That's the first item for.
Okay, first item in admission, na? So that one is, yours is 184, na?
One bit for
There's
this.
one if it is separate maybe and this one is only reserved. So for tomorrow. And send the files to my room.